Will you please your lordship, I beg to mention an item for listing. I beg to mention an item for listing. It's a pending matter, your lordship. The petitioner is a professor in.
For listing, you approach the registry, okay, for listing.
Your lordship,
Don't mention listing matters. You approach the registry.
I also want to mention for listing of a deed petition. Also, the petitioner is an old lady. She is not getting the family pension for the last 4 years.
You heard just what I just said. You approach the registry.
Not true.
There's a mechanism in place.
Not true.
Any mentioning from the cost list?
May I please, your lordship? I beg to mention item number 21 with the consent of the other side.
I thought the respondent 7.
21.
Yes, I'm the petitioner and this is for the respondent number 7 with the consent of the other side. It may be taken up after 2 weeks.
Why?
We supposed to file our affidavits on.
What, rejoinder affidavit?
Rejoinder.
Okay, learned counsel for the petitioner placed for the 2 weeks time to file rejoinder affidavit. So, as the same is not objected to by the other side. Matter stands adjourned for 2 weeks on a date to be listed by, as fixed by the registry.
May I please, your lordship? First, I mention item 32, lordship. 32, lordship, this matter become infractious, lordship.
32.
Yes, lordship.
What is your good name?
S. Islam, lordship, on behalf of Ami Mahmood.
S. Islam.
S. Islam on behalf of Ami Mahmood.
Mr. S. Islam, learned counsel, appearing on behalf of Mr. M.U. Mahmood. The engaged counsel for the petitioner submits that the matter has become infructuous. Who is appearing for the other side? No one. In view of above, the writ petition stands disposed of as infructuous.
Deeply obliged. Item number 9, matter become infractious. Item number 9.
Your N. Islam.
Yes.
Mr. N. Islam, learned counsel for the petitioner submits that the matter has become infructuous. In view of above, the petition stands disposed of as infructuous.
May it please your lordship? I beg to mention item number 23, lordship. The engaged counsel is suffering from illness, lordship. The matter may be adjourned for the day.
Who is that?
HMR Chaudhary.
Okay, what about Mr. Chaudhary, H.R.A. Chaudhary? Senior counsel is also sick.
No, HMR Chaudhary is on leave. He will do the matter.
He's on leave or sick.
Sickness.
Okay. Mr. A.H.M.R. Chaudhary, learned counsel for the petitioner. Before counsel, you write conducting counsel. Learned conducting counsel for the petitioner is said to be indisposed. Stop on a prayer made on his behalf. The matter stands adjourned for 2 weeks.
Lordship, a date may be given. Any date may be given.
Will not give a date, but adjourn for 2 weeks. Registry to release the matter again after 2 weeks on a date to be fixed by. All right. Next.
In item number 1, we have filed an affidavit in reply to the matter, and we have also served a copy matter. That may be called for.
Item 1, you file reply.
Yes.
Okay.
Anyways.
May I please, lordship? Lordship, I have to mention item number 22.
22.
22.
22, yes.
Due to some personal difficulties, the responsible appear before this court. Right. So kindly adjourn the matter for the and fix an
You're mentioning for the petitioner.
petition.
Who is having difficulty? M.K. Mishra.
His father will expire.
Okay. Mr. M.K. Mishra, learned counsel for the petitioner, is said to be in bereavement. Stop on a prayer made on his behalf. Matter stands adjourned for 2 weeks.
I get to mention one rectification pertaining to family pension matter. The petitioner is having some problem. Some others. The returnable date is over.
You,
Any convenient date on this?
you approach the registry.
Any date in the next week?
Approach the registry. There's a mechanism in place, Mr. Counsel. You must have heard what I've said.
First one.
This is through VC.
Item number 4, you will lead that. Can this be taken up after some time? The AG will be able.
Plus somebody had mentioned about reply affidavit also.
They have also requested.
Let it come up after some time.
After.
Okay. How many matters are similar?
There are four.
Item 1, 2,
3, 4. 1, 2, 3, 4.
1, 2, 3, 4. Okay. Pass over for the time being.
Orders, item 88.
Yes. Why is it listed today? Review.
On the.
As per the last order.
For the last order, my lordship calls for the minutes of the 11 to 2016. I've received the minutes.
Why was it called the minutes?
Well, basically, this honorable court, while disposing the petition, took into consideration that the district level scrutiny committee has recommended the name of the petitioner, and therefore he has acquired a right under section 4 of the 2011. Now, the writ petition doesn't contain that minor. There was an order of the inspector of school, which reflects that the district scrutiny committee on 11 to 2016, after the matter was remanded back by this honorable court, took into consideration the seniority of the petitioner and the respondents of, and pursuant to that, the district scrutiny committee has relegated the matter to the inspector of school to determine the seniority. After the seniority was determined by the inspector of school, thereafter the district committee, before the district scrutiny committee could proceed further and recommend the name of the petitioner, well, the act was struck down. And that, however, this honorable court, the annexure 7 of the writ petition, considered it as a recommendation of the district scrutiny committee. So our contention in this review is that the order that was passed by the inspector of school cannot be construed as a recommendation of the district scrutiny committee.
Actually, what was the order about? Seniority?
Provincialization.
No. District, what do you call? Elementary education officer.
The inspector of school.
Oh, inspector of school.
Inspector of school determined the seniority.
So that determination of seniority was.
That would not amount to recommendation of a district scrutiny committee for provincialization.
Determination of seniority was considered as a recommendation of the DLC.
Yes.
But these are two different things.
Two are different.
Isn't it? But where are those documents?
Madam?
Which are the documents?
One of the writ petition did not have the minutes of the district scrutiny committee. If your lordship will kindly see.
But where is the where is the determination of the seniority? By
that is page 52 of the page 52 of the review petition.
Review.
That is annexure 7 of the writ petition. And this order is very clear. Page 52. Lordship will find in the third paragraph, your lordship will find.
The last line speaks that he may be considered.
He may be considered. But therefore, third paragraph, your lordship will kindly see third paragraph first. 1, 2, 3, fourth paragraph. The district level selection committee in its meeting directed the undersigned to issue a speaking order on the basis of the proceedings of the meeting dated 11 to 2016. Accordingly, DLC perused and seen all records paper relating to the petitioner grievance and re-examined the records particulars of the staff paper submitted by the headmaster Jungle Block in prescribed format to the district scrutiny committee for provincialization of the service of Abdul Khalek, Marjan Begum. It is the writ petitioner, now respondent in the review, and Mohammad Ahmed Ali Talukdar. It has been found that the date of joining of Abdul Khalek is so-and-so, Marjan Begum is so-and-so, and Ahmed Ali Talukdar is so-and-so, which reflects that Mohammad Ahmed Ali Talukdar is junior most amongst them. Hence, the service of Abdul Khalek and Marjan Begum may be considered for provincialization. So now, based on that speaking order, it ought to have gone to the district scrutiny committee to take a decision for recommendation of the provincialization.
Then where is the order of the court?
Yes, that is page 59. Page 59.
Hmm.
Lordship will come to page 61, paragraph 4.
Yes.
The subject matter of that petition. The WPC 5530/2012 was given a final consideration by order dated 23/11/2015.
Just a minute.
My lord.
What is 5530?
5530 was the earlier petition.
Same person.
No, it was by the private respondent. Seven.
By
Ahmed Ali Taluk.
Ahmed Ali Talukdar.
Yes.
Oh. All right, yes. Carry on.
With a direction to the district level scrutiny committee in short, DLSC to examine the claim of the respondent number 7, Mohammed Ahmed Ali Talukdar. The DLC upon such examination arrive at its conclusion that the petitioner Marjan Begum is senior to Mohammed Ahmed Ali Talukdar and therefore would be entitled for provincialization. This petition is instituted and nothing further has been done and recommendation of the DLSC made in favor of the petitioner had not been acted upon. Considering the limited grievance raised, we dispose the writ petition directing the Director of Secondary Education to bring the recommendation of the DLSC made in favor of the petitioner to its logical end by passing an appropriate order. As it is a case of deemed provincialization under section 4(1) of the Act of 2011, in the event the authorities are of the view the petitioner satisfies all requirement of section 3, which in fact would be as because DLC had examined and the matter and recommended in her favor, the benefits of provincialization be made applicable from 1/1/2013 as provided under the Act of 2000. So apparently, my lord, there was no DLC's recommendation in favor of the petitioner. In fact, that was the order
Now,
passed by the inspectors.
tell me, how was this 5530 taken care of earlier?
5530.
It was disposed of by directing that case of the petitioner
Yes, that is page 42.
should be examined,
Yes,
correct? But later on, this Marjan Begum came
yes,
saying that her name indeed was found to be, she was found to be senior by the inspector of schools.
yes.
And on that basis, she should be considered. So this court took into consideration the finding of the inspector of schools
As a
one
recommendation.
of which is a recommendation. And
Recommendation. of-
accordingly directed that it should come to a logical conclusion.
Yes.
So that is what you agree to.
That is one first.
Mhm.
Now, another aspect, assuming if it is the district scrutiny committee, even if it has recommended it, that will not confer any right for provincialization. Because the act of the provincialization has two schemes. One, the district scrutiny committee will recommend it will go to the state level scrutiny committee. The state level scrutiny committee, upon further scrutiny, will prepare a list of eligible candidates for provincialization. And thereafter, it will be placed before the government for approval. So until that government approves and issues a notification, but the benefit of section 4 that deemed provincialization, that right will not come.
11/2/2016, what is this? Meeting minutes?
11 to 2016 is the minutes of the DLC.
DLC.
Here, even 11 to 2016, what the inspector in that 30/07/2016 order, which your lordship has found at page 52.
Hmm.
The DLC relegated the matter back to the inspector of school to pass a speaking order in terms of determining the senior.
So that DLC's order is 11/2/2016.
11 to 2000.
So, and the inspector of schools did that on 37/2016.
37 to 2000.
Five months down the line.
Well,
So last court date, you were supposed to produce that meeting minutes,
Fine.
isn't it? It's only a referral order.
yes, it's only a here it says against the IS NDC Nogao has been directed to issue a speaking order on the basis of the proceedings of the DLC in compliance with the order dated so and so meeting ended with a vote of thanks from their chairman.
It's been printed here. Or why is there an overwriting in the date? 11/2/2016.
Like this minute melody, it is seen melody, the other member signatures over. Because
The signature is there, but date is
no,
not
no,
there.
signature only melody, the two signatures are there.
So there's something missing. There's an overwriting on 11 and in the month as well as in the year.
See.
The first paragraph, we have an extra copy with you.
But yes,
The first paragraph or second paragraph rather,
madam,
that High Court's order dated 23/11/2015, it says. To
yes,
dispose of the petitioner's grievance within a period of 2 months. Was that the direction?
yes.
To dispose or to consider?
No, no, to dispose. That High Court order, your lordship will find the earlier page 51. Page 50, paragraph 7 onwards is the direction.
Page 50.
Page 50. Down below your lordship will find paragraph 7, one line. The district scrutiny committee shall dispose of the petitioner's grievance within a period of 2 months from the date of receipt of a certified copy of this order, along with the copy of the writ petition. A perusal of the educational qualification of the respondent number 6 would go to show that the respondent number 6 has acquired the qualification of zoology, geography, and mathematics. The division bench has clearly held that the seniority has to be counted as per the second proviso to section 4(2) of the Act of 2011. It is not disputed at bar that the respondent number 6 is more senior to the petitioner and the respondent number 7, as he had joined the school as a teacher earlier than the petitioner and the respondent number 7. In that view of the matter, there can be no infirmity in the order dated 22/09/2015 provincializing the service of respondent number 6. With observation and direction, this writ petition stands disposed of. Basically, the challenge in that writ petition was with regard to subject combination.
So this meeting of the district level scrutiny committee, which you have just passed on,
Right.
is it not a recommendation?
No, ma'am.
How do you say that?
Because the inspector of school has been asked to issue a speaking order.
Who will who will give the recommendation?
It is the district level school.
So this is the meeting minutes of the
No.
DLC,
It say may be considered for provincialization.
correct?
It is not said, it doesn't say that so and so is recommended for provincialization and it should be placed before the state level committee or the director.
It doesn't say in so many words, but it does
But
make a
The,
distinction.
the act, my
One,
lord,
Talukdar was there, then the Begum was there, then Khalek was there. So
lordship will kindly,
out of these three, Begum and Khalek has been found to be eligible to be considered for provincialization. What more can they say? Like you said, it comes in three stages.
Yes.
First DL district level, then state level.
Right.
After state level recommends, they have to prepare a list. And the list has again to be approved by the government.
Yes.
So apart from saying that it may be considered for provincialization, what more can the district level say? Can they say that you provincialize directly?
No, your lordship will kindly
So
take up the 2011 Act for a moment. May I just,
where do you find that 11 Act? This which book?
Manoj, in this book, your lordship will find 647.
Which book is that?
Same
Education manual,
education.
page number.
647.
Yes.
The page 658 is the District Scrutiny Committee,
Yes. Read.
section 10. There shall be one district committee in each district separately for elementary, secondary, and for higher education to scrutinize the service records and other related issues of the serving teachers and the staff of venture educational institution pertaining to provincialization of their services. The deputy commissioner of the district by an order shall constitute the district scrutiny committee for the respective district under preceding subsection. The district scrutiny committee shall first scrutinize and prepare a list of all venture educational institutions within the district which are eligible in terms of provision of this act and shall thereafter proceed to scrutinize and verify the service records of the all serving employees who are eligible and would become eligible for being considered for provincialization of their services. The district scrutiny committee, this is very important. The district scrutiny committee shall forward the verified list of eligible teachers school-wise in accordance with the number of posts specified in the schedule appended to this act to the concerned director, who shall, after making such further scrutiny as may be required, shall forward the same to the concerned department of the state government for consideration and for issuing notification in respect of the eligible institution and employees eligible for getting their service provincialized. The district scrutiny committee shall have the powers to inspect all documents, records produced before it and call for such further records and documents as may be required for the purpose of causing verification and scrutiny and examine witnesses for the purpose if considered necessary, and while doing so, it shall have the powers of a civil court for the purpose of compelling attendance of the so and so. Now, your lordship will kindly see the subsection 4 says, my lord, after the district scrutiny committee verifies the particulars, the service of the teacher, they will prepare a list of the eligible teachers in respect of the schools. And that list has to be forwarded to the state level scrutiny committee.
Correct, maybe. But the thing is that now we are coming to some disputes here.
Well,
A few people have approached this court by filing writ petitions.
Right.
So ultimately it has boiled down to three persons.
Yeah.
Abdul Khalek, Marjan Begum, and Abdul, and who's the other one? Ahmed Ali
Ahmed Ali
Talukdar. So this has somehow come down to these three persons. So by reading the provision, you're saying that it should be in such kind of format. Only then it will be accepted as a recommendation.
no, this district scrutiny committee is minor,
Hmm.
cannot be considered as a recommendation in my respectful submission is because this district scrutiny committee again has relegated back to the inspector to pass a speaking order. So district committee has not recommended it to be to the director as per subsection 4.
Okay, the inspector has passed a speaking order,
Yes, that speaking order is
37.
yes 37.
37, 2016.
2016. In reference to the direction of the district scrutiny committee.
So thereafter, if they had relegated it to the inspector say that is the senior most, then the district
This
level
district
scrutiny
scrutiny
committee has
thereafter-
to take a call again.
Yes, that was ought to have been a final call for recommendation.
That was not there.
That was not. And prior, that would have happened.
And prior to that, the writ petition was disposed of. No, 28/10/21. Long time thereafter.
Yes.
What happened after this speaking order? Page 52.
Pardon?
After page 52,
After page 52, they have instituted this petition. Wherein this honorable court has taken this 37/2016
Oh.
order passed by the inspector as a recommendation of the district scrutiny committee.
Hmm. What does this mean? Again, the ISNDC Nagon has been directed to issue speaking order on the basis of the proceeding of the meeting of the SC in compliance of the order. 533. 5330 of 12.
Fixing the seniority.
533 of 12. Where is the 533 of 12?
533 of 12 is
That order?
starts
533
from page 46.
46.
Direction which I read at page 50,
Yeah.
para 7.
So. Because 6 is more senior. How many persons can be recommended?
In the science, two in the category of science.
In the category of science?
Science.
Abdul Khalek and Marjana Begum, they are both.
Abdul Khalek was already provincial.
Okay. But where's the direction to verify?
Paragraph 7.
Shall dispose of the.
The grievance with a period of 2 months from the date of receipt.
Along with a copy of the writ petition. Then the Abdul Khalek was not disturbed.
No, Abdul Khalek was not.
One was not disturbed. Only grievance of the petitioner was to be looked into.
One more aspect, if your lordship will kindly see.
So what is this reference here? Against, again, the so-and-so, the inspector of schools has been directed to issue a speaking order. Who was directed to issue a speaking
The
order?
district scrutiny committee.
No, in a compliance of the court's order dated in W. Court has not directed anything like
Court
that.
has not directed. The district scrutiny committee, on the basis of the proceedings of the meeting, has directed to issue a speaking order for declaring Marzan Begum as to and Khalek as to be the senior.
Okay.
One more aspect, if your lordship will kindly see, page 62 of the order against which we are seeking a review.
62.
Page 60.
Yes. Yes. What is there?
The first, page 6, the paragraph starts from page 61. Considering the limited grievance raised, we dispose the repetition by directing the Director of Secondary Education to bring the recommendation of DLC made in favor of the petitioner to his logical end by passing an appropriate order. But till this, it would have been okay, because the director, otherwise this statute gives a power to the director to take a final call on the recommendation of the district school. Now thereafter,
But you said there's no recommendation.
no, there was no recommendation.
Then
Even this,
at the same time, you're saying that.
no, even if if there would have been a recommendation, the director can take a call. Now here, this honorable court has gave a finding, well,
Hmm.
as it is a case of deemed provincialization under section 4(1), in the event the authorities are of the view that the petitioner satisfies all requirement of section 3, which in fact would be as because DLC had examined the matter and recommended in her favor, the benefits of provincialization be made applicable from 1/1/2013 as provided under the Act of 2011. Well, this issue has been decided by this honorable court in several petitions, my lord, in several cases. One which I'll like to place, that the recommendation of the district scrutiny committee would not confer any right of provincialization under section 4 for claiming deemed provincialization.
No, it cannot be. Like you said, there are three tier systems.
Yes.
District, then state, then final list. So that process has to go, has to be put into motion. Here is only an observation that since there's a recommendation, which according to is not a recommendation.
Yes.
uh,
And apparently, my lord,
Bring the
the-
same to its logical
and
conclusion.
apparently, my lord, the writ petition doesn't contain any document showing that the district level scrutiny committee has recommended. Well, that's a apparent error, my lord, in my perception.
So take me to your grounds.
Start from page 9. Paragraph 12, page 12, ground F, my lord.
This is what you said. Okay. So although you have raised so many grounds, I think the issue is limited to this only.
My lord. With the other grounds which I have raised, one is, my lord, after the act has been struck down, my lord, there cannot be a direction for provincialization under the struck down.
When was it struck down?
It was struck down on 23/9/2016.
But these recommendations, so-called speaking order, minutes, all that, these are before that, isn't it?
Yes.
So under that circumstance, what will happen?
No, this recommendation, even if it is considered to be a recommendation by the district scrutiny committee, that recommendation has not got to the stage of 10-4.
10-4 is what you read.
Yes.
That's it, Mr. B. Kaushik.
My lord.
Anything else?
And, my lord, regarding 10-4, my lord, then. Oh, my lord. What you will find in the third phase, my lord, fourth phase, my lord. There are no resignation. Down below, the paragraph starts from Assam Venture Education and Institution Provincialization of Services Act 2011.
Hmm.
Has been enacted to provincialize the service of the employees of venture educational institution in the state of Assam and to restrict further establishment of such institution in the state Since it is admitted that the school in question is a venture educational institution, it is necessary to devolve into the definition of venture educational institution as given in the 2011 Act. Under section 2H, teaching and non-teaching staff of the venture education is appointed in the concerned venture educational institution before 1/1/2011 would be entitled to provincialization. Eligibility criteria for provincialization is mentioned in section 3. Under section 4, upon provincialization, the teaching and non-teaching staff would be deemed to be employees of the state government, and their terms and conditions service would be governed by the service rules applicable to the state government of employees of the corresponding ranks. Since in the process of provincialization, there are bound to be claims and counterclaims leading to dispute, section 10 of the Act of 2011 lays down the procedure for scrutiny of the claims for provincialization. Section 10 envisages scrutiny at 3 stages. Firstly, at district level, through the district scrutiny committee constituted separately for elementary, secondary, and higher. Secondly, at the level of the director, and lastly, at the level of the state government. Subsection 4 of section 10 provides district scrutiny committee shall forward the verified list of eligible teachers and staff to the concerned director, who shall thereafter make such further scrutiny as may be required and forward the same to the concerned department of the state government for consideration and final decision. Subsection 4 to section 10 read as under. I'm skipping the subsection 4. I've already read it. The fine.
Mr. Kaushik, one thing,
Well,
the level of district and directorate and state, is this the state?
yes.
District, then I think it's the state.
District
Director
director
comes in between.
comes in. That is subsection 4. Here it is quoted, my love. District scrutiny committee shall forward the verified list of eligible teachers school-wise in accordance with the number of posts specified in the schedule appended to this act to the concerned director, who shall thereafter after making further scrutiny. So director is the second step. As may be required, shall forward the same to the concerned department of the state government for consideration and for issuing notification in respect of the eligible institution and employees eligible for getting their services provincialized. Coming further, Malab, from a careful reading of section 10 of the Act of 2011, particularly subsection 4 thereof, it becomes clear that the verification or decision of the district scrutiny committee is not the ultimate or final. District scrutiny committee does not have the final say in the matters of provincialization. It is an ongoing process of scrutiny, and what happens in the present case is that the first stage of the district scrutiny committee has been completed. No doubt, district scrutiny committee has scrutinized the claims of the petitioner and respondent and found them to be not entitled to provincialization. The decision of the district scrutiny committee now be subject to further scrutiny of the director of elementary education as he may consider.
Oh, please pause there for a moment.
Well,
If it does not clear the district scrutiny level, how does it end up in the directorate level?
no, my argument for this, Major, the district scrutiny committee, even though have recommended
No,
the
even
direction-
though they have not recommended, then will still go to the director,
no,
who will overrule the district scrutiny decision. This is what it says.
yes, the earlier that Act of 2011 did not have the provision of appeal. Now, which is there in the 2017 Act.
See, no doubt the district scrutiny committee has scrutinized the claims of the petitioner and respondent number 9 and found them to be not entitled for provincialization. This decision of the district scrutiny committee would now be subject to such further scrutiny by the director. So even if it fails there in
Fails.
district level,
They can
still-
approach the director.
it still
For
goes to the
further
director. They can approach.
They can approach.
So was this a case of approaching the director? Which you're reading this decision?
No, they assume that the order of the inspector of school as a recommendation of the director, district level scrutiny committee. Their grievance in that petition was that though district level scrutiny committee has recommended their services for provincialization, but nothing further has been done. And at that stage, they have approached this honorable court.
No, it says not entitled. The district
No,
scrutiny
this
found
is
that.
in this petition.
No, in the review petition. The case connected to the review petition is nothing has been done, although it was recommended.
Although it was.
But in this judgment, which you're just reading, The
There
facts,
the
the facts are that both the petitioner and the respondent therein were not recommended,
recommend.
yet it was taken up before the director.
No, court said that yet it could have been taken up before the direct. As that rejection is not a final rejection.
Oh. Anyway, the purpose of your relying upon this judgment is basically section 4,
Section 4.
subsection 4.
Subsection
10.
In fact, the division bench has also held that, Miller, that after the act has been struck down, there can be no mandamus under the act which has already been struck down. The division bench of this honorable court.
Where is that? But you see the quorum of the bench. You're pitting against the same thing. Which paragraph?
My lord will kindly see. Paragraph 4 was the prayer in the petition. It is
Paragraph 4.
paragraph 4.
What is the date of the judgment?
It's changed the judgment is
2019.
19. Paragraph 4.
Yes.
The sixteenth line from the top, my lord. The line start from despite such recommendation by the district scrutiny committee. My lord finds
In paragraph 4.
in paragraph 4.
Yes. Got it.
Yes, despite such recommendation by the district scrutiny committee, the petitioner had been taken out of the purview of the provincialization of service under the Act of 2011. It has been pleaded that the school had been provincialized by the government of Assam, as communicated by the deputy director, but the name of the petitioner has been dropped in the said impugned order. So far, it relates to the service of the petitioner. Consequently, it is evident that the Act of 2011 has been violated. We need not go into the other intricate details in regard to the case of the petitioner. Because the Act of 2011 was constitutionally invalid by judgment reported as 2016 5 ZLT titled Sandan Kumar Neog versus State of Assam and others. Contention of the learned counsel for the petitioner is to the effect that though the Act of 2011 had been struck down as constitutionally invalid, however, review petition was filed in context of the judgment. The review petition bearing number so and so was decided by judgment dated to 2/1/2017. It has been pleaded on behalf of the appellant that at the point in time when judgment in Sandan Kumar Nag Supra was rendered, right had already been vested in the appellant and therefore she is entitled to benefit flowing from order rendered on the review petition. The contention of the appellant has been rebutted by the learned counsel for the state respondent on the ground at the point when the judgment was rendered in Sandan Kumar Neog, order dated 21/8/2013 was in vogue. It is therefore evident that no right had been created in favor of the appellant. Services of the appellant had not been provincialized. The appellant was not drawing salary as a provincialized servant. In such circumstances, neither in facts nor in law, it can be construed that the right was vested in the appellant and therefore be given the benefit of the order passed in the review petition. We, having considered the rival contention, deem it proper to extract the relevant portion of the judgment rendered in Sandan Kumar Neog Chupra. Relevant portion of the judgment in contained in paragraph number 34, 35, 36, 37, 38, and 39. But this litigation reveals that non-application of mine, it is all pervading in the state enactment. The discriminatory impact of the provincialization act is found to be glaring here. In order to avoid impermissible discrimination, the classification must be founded on an intelligible differential, which distinguishes persons or things that are grouped together from other left out of the group. And also differential must have a rational relation to the objects sought to be achieved by the state in question. The petitioners here project that the teachers whose services are provincialized and those who have been left out are at far in all aspects. In most cases, both categories have been rendering service in the school since inception and are similarly qualified as well as rendering similar duties. There is nothing on the face of the statute or the surrounding circumstances to show any distinguishing factor. Also, no rational relation of such differentia with the object of the act is discernible from the reading of the provision. In fact, that the object of the act is to provincialize the service of the teachers in venture educational institution and prevent further growth of such institution. However, the object of the provincialization of service of the required teacher in the institution established bona fide stand negated by the enactment in its present shape. The venture school, which was set up bona fide on need basis, in our perception, do serve the students in remote places, and it may not be wrong to say that due to inability of the state to discharge its constitutional obligations, the venture educational institutions were allowed to function. We may also say that the state has been discharging its constitutional obligation through this venture educational institution. In this backdrop, when the venture schools are taken over, the government in a sense is taking steps toward discharging its constitutional obligations. However, the action of the state in taking over such schools with only a given number of teachers, when the number is not commensurate with the prescribed requirement of the RT Act, the law frame for implementation of Article 21A, the relevant prescription is absolutely arbitrary. The spirit of Article 21 states A stands defeated in our perception if the mechanism prescribed under RT Act is not conformed to encourage those bona fide elements who have aided the state in discharging its constitutional obligation. It is also questionable whether the mode of entry into government service facilitated by the Provincialization Act can ignore the applicable reservation laws relating to SC/ST category, women and disabled groups. The role of the authorities in the field of education in 6 civil areas of Assam is also undermined by the Act of 2011. The appointment of teacher in the venture educational institution is not competition based and is opaque, and therefore quality of education is bound to suffer if this is allowed to continue. This naturally will negatively impact the next generation of our state. Moreover, the norms and qualifications prescribed by the competent authorities like UGC, NCT, SEBA, etc. is the major casualty in the application of the Provincialization Act. When such substantial defects are perceived in a given context, the court can strike down only the offending provisions. However, when the unconstitutional is noticed in the
Mr.
major...
Kaushik,
Hello.
I've read it.
Yes.
See, tell me one thing, who would be eligible to be provincialized? Person who already gets the pay of a provincialized teacher. Is it?
No. Here the division bench has said, admittedly, the person was not provincialized, and therefore there cannot be a mandamus.
It says admittedly the petitioner was not getting salary as a provincialized employee.
Yes.
Therefore, it would be a fallacy in law and facts to consider that the right had already existed. Is it a precondition that you should have that salary?
No.
Then
The salary with on the word provincialization itself means well taking over the services of the teachers of the venture education. On the
Correct.
date, from the date they are provincialized, they will be paid salary by the government.
but prior to their government salary, what salary are they getting? Is it
No,
at
they are
par?
not getting it.
Is it at par with the government salary?
At one point of time, they were getting financial aid from the government. The school used to get financial assistance from the government.
So whatever the amount may be, is it not at par with the government salary?
It was there.
Then why this para 9?
No, it was to say that the appellant was not a provincialized teacher. He tried to claim the benefit of the benefit that was given by the review petition after the act was struck down. That review, in the review petition, the benefit was given to those teachers who have already been provincialized before the act was struck down.
Who has already been provincialized?
Who has already been provincialized. So that benefit of provincial, the benefit that was given by the review
So whatever has been done cannot be turned back.
cannot be done.
That was the principle. And the appellant or the petitioner,
As the High Court, while striking the act as unconstitutional, did not have the power to give a prospective overruling. And therefore, the state filed that review petition.
no, see, the review petition, in fact,
Was filed by the state.
okay, it was filed by the state.
It was filed by the state.
To take away those benefits which has been given to them
Because the once
in
the
view of the act being struck down. The court said that they have already enjoyed that benefit. So there's no question of
it
turning
was a
back.
commitment given by the state that until the new legislation is brought, the persons who have already been provincialized, their services will not be
Yes.
In fact, when the act was struck down to be unconstitutional, so any services that was provincialized under that act becomes an unconstitutional. And the High Court did not have the power to give a prospective overruling. And therefore, state by way of that review petition asked for an exemption from the court that the persons who have already been provincialized prior to the declaration of unconstitutionality, those teachers' services would not be touched by this court, the state, till the new legislation is brought. And therefore, the new legislation 2017 Act contains a provision at section 24.
It says,
It says reviewing of all the services that has been provincialized under the Act of 2007.
reviewing.
That provision, my lord, will find at page 126. Section 24 is the repeal and savings plan.
Their cases shall be reviewed as per the eligibility norms.
Because necessarily, my lord, when the act has been declared to be unconstitutional, any act that is done under that act becomes unconstitutional from its inception.
So what was the order passed in this Vimal Kutu
My lord,
review petition?
review petition, which was the division bench, my lord, discussed the law relating to the prospective overruling and say, as the state has given a commitment of bringing a new legislation, and till that legislation is brought, those teachers who have already accrued the right under the unconstitutional act, their services would not be terminated.
But why did the state to prefer a review?
Because immediately, because there was a chaos.
It would have been the employees themselves who should have gone for a review. We have already been provincialized.
But it could safeguard the situation that this teachers, the services were provincialized after the Act of 2011. Automatically, because when it was declared to be unconstitutional, there would have been situation reverting back that those services would also will go. And the power of prospective overruling.
So, the state took the responsibility.
State took it.
Otherwise, it would have been the persons who are likely to be affected to come and pray for the protection. Instead, the state came.
Here, the division bench order para 10 is very clear. Tell you.
Then, if that was the case, what was the contention of the state? In the writ petition, the present writ petition.
The present petition, no affidavit was filed. In fact, this was disposed, so saying that as it is a limited grievance, that no district scrutiny committee is recommended.
2000 Act was rendered unconstitutional on which date?
It was rendered on 23/9/2016.
2016. Then this writ petition was disposed on 2021. So that was known to the court, that was known to the parties.
Well.
How do you claim the benefit under the act which has been struck down?
In fact, there had been lots of orders of subsequently when these orders were passed. Now, it's like a recent order. There is a series of cases also which claim the benefit of 2011, where this honorable court.
Mr. B. Kaushik, after such kind of all these arguments, we're going back to square one now. It was known to you in 2021 when the writ petition was being disposed of. Act is struck down, so they cannot have the benefit.
So there was one judgment by this honorable court.
And how do we?
No, that judgment has been distinguished by the coordinate bench of 2-3 in 2-3 judgments.
Court was also aware that this is struck down. Despite that, it was given.
But the court construed that as it is a deeming provision, therefore a legal fiction has already been created.
It could have reported at appeal instead of a review. Then
Well, in fact,
review is only on that ground of that there's no recommendation. Court said that recommendation. This is not a DLC recommendation.
yes,
This is your ground.
that is one.
That is one. The other part is
The
that.
other part,
since-
sir, there could not have been a recommendation, but the mandamus in respect of a act which has already been struck. In fact, the Honorable Apex Court, my lord, in a 3 judges bench, in a 5 judges bench recently also has clarified this position, my lord, that once the act is declared to be unconstitutional, there cannot be any enforceable right. In my lord, CPI versus RR Kishore.
Is that one of your ground in your review petition?
Yes, sir.
It cannot be. Seeing the parameters under which a review can be maintained. Despite
is-
due diligence, you were not aware about this, the such provisions of law would be one ground. Act itself was struck down. And parties were required to know that this is what is happening because you're claiming the benefit under the same act.
This is an order which is passed.
So it is not a case where you can say that we did not know about these things. You knew about it.
Says a kind of order wherein the Honorable Court has died, considering it to be as a limited grievance has given this direction. Saying, and therefore my first round of review is that there was no district scrutiny committee even to come to a conclusion that there was a recommendation.
Anyway, we'll do one thing, we'll post this matter some other day. I think it needs further hearing. There are many matters in line, so we are just, we cannot conclude this. Mr. Dekha.
Yes, my lord.
Please write down. Mr. B. Kaushik, learned counsel for the review petitioner is present, as well as Mr. P. K. Dekha, learned counsel for the respondent. In terms of the last court's order dated 26/2025, Mr. B. Kaushik has produced the meeting minutes of the DLC Nogam dated 11/2/2016. So however, on perusal of the same, it is seen that there is some overwriting on the date. And therefore, Mr. B. Kaushik shall produce the original file for perusal of this court. Okay, I think they'll be proper. It should not be just overwritten like that. This matter again. After 2 weeks on a date to be fixed by the registrar. Partner. Not as partner. Yes. Let it be. Yes. Get down. Public. Which one? No, will not be partner. Let it remain as it is. See, I don't know. See, we don't know the roster, so I don't want the matter to be stuck up like that.
Otherwise, by other period again, this stuff for the other, only humble friend, get the partner. Try our luck.
No, we'll not keep it as partner. It's the council. We can take it up again. There's no issue about it. But let it not be a partner so that it doesn't get stuck up with you.
Maybe it's not.
We have directed.
Yes.
I'm not fixing any particular date like the other days. I'm saying that I'm directing the registry to fix a date after 2 weeks. They will do it. One, two, three, four.
And we find last word minor to get that. Kindly tell us the last word minor in the content. Today is the day for submitting the compliance order. And it is now under the government, there is not the excuse manner to the answer report as well, report is always directed. The content of two.
Where's the order? Not complied with.
But compared to the content paper, find page there, 9, start from 9, page 21. Mandamus is given clear, Mandamus is given.
Show me the order, operative portion.
Operative customer development file at page 19, that's 10. That's from 10.
19. Was it a common order?
Both the cases are of the same petitioner.
Order passed in what, review petition?
Yes, mainly review. Allowing the review petition, my lord.
How many cases are involved here?
Only 2 cases.
4729. 3386.
1016 2021 is the review petition, my lord. 106 2021.
Review petition of which orders? Passed in which case?
Passed in, my lord, order dated 27/6/2024, passed in review petition number 106 2021.
No, review petition arises out of which case?
Oh. Earlier case, my lord, it was,
WPC number?
3386 2018, my lord.
I see. And then what about 4729?
4729, my lord, what happened?
Is a different case.
No, it's connected. After filing of the petition 4729 2021, my lord, this honorable court, my lord, stated though it's a consequential order passed on the order of the or based on the order of the honorable court, you have to prefer the review petition before the appropriate court in respect of the earlier petition. So the review petition is subsequently preferred. And both the cases are disposed of by the common order. Page 20, Roman 4, my lord. The original petitioner during the pendency of the proceedings having been passed away, the pay and allowances now due to him, along with other benefits that would so accrue to him on account of the said provincialization of his service in the said school with effect from 1/1/2013, shall be now so released to his legal heir after deducting the amounts already paid to the original petitioner during his lifetime.
Then who's respondent number 8?
Respondent number 8 was, my lord, the private respondent who prepared the petition earlier. And his petition was allowed wherein he challenged my provincialization order. That was allowed. And after that, we preferred the review petition, and then the review petition is allowed, my lord, modifying the direction of the earlier.
Now, what is the connection between the petitioner and the review petitioner?
Both of them were teachers. The petitioner hereof, her husband was the senior most teacher, and the petitioner court has determined that I am the senior most teacher, and that's why my provincialization is in the stroke in the review. And you are the junior to me, my.
Mr. U. Sharma, what is your instruction?
Here, madam, the director is written to the government to examine the matter, madam. So some time is required, madam. It is pending on the under the government section.
What they have done, madam, after the decision of this court, without any authority, they have conducted one separate hearing of the petitioner as respect of a case. That is not permitted. Either you go for the appeal in the higher forum, or you comply with the order. What is their location to conduct, my lord, inquiry and hearing, madam?
Have you stated that in your contempt petition?
It is, my lord, after filing of this contempt case, they have conducted.
So you should have filed an additional affidavit to bring all those information.
If at this stage, my lord,
Now, Director has been given the direction, isn't it? What has he done? He's referred the matter to the government.
Yes, ma'am.
Why? How?
Actually confusion is there, it is the provincialization was occurred under the Act of 2011, which was subsequently struck down. So, it is referred to the government now to examine the matter.
When was it
It
referred?
is my staff.
Is that permissible? Either they have to prepare a pitch or they have to come.
Ultimately, final decision will take my lord the government. So,
Decision has been taken by the reasonable court, they have to comply with the petition. What decision they want to take further, it's about reasonable. Original decision expired, but the wife is the petitioner.
Mr. Sharma, the court had passed a direction on 27/6, correct? And now the director has said that it cannot be complied with by writing a letter on 24/7/25 after more than 1 year.
Due to multiple cases, what pending, so hearing was also conducted here.
And you have not filed your show cause.
Hereafter,
You have also not filed your show cause reply.
We will file.
Huh?
We will file.
No, we don't have to request you to file. If you don't want to file, don't file. Let him come here personally and explain why he has not complied with those directions. Because the court, the contempt jurisdiction, we cannot go for rehearing. Rightly or wrongly, some decision was taken. You have to comply. If you have any difficulty, you have to take recourse to appeal, review, whatever. That you have not done. And now you say that you write to the government saying that we cannot comply. What is this? This is not acceptable. Let the director come and explain. Last time for what? You are also helpless. I know you are a counsel for the director. You are helpless. But you should also impress upon the director that this is not the way things are to be handled. There may have been some error in the order, but that doesn't mean that he will not comply without taking recourse to any other remedy available to you. Please write down. Part Mr. D. Prokashta, Lanet Counsel for the petitioner. And Mr. U. Sharma, Lanet Counsel for respondent number. Which respondent?
Number 2.
Respondent number 2. That is the Director of Secondary Education, Assam. Stop. This contempt petition has been filed, alleging willful and deliberate violation of this court's order dated 27/6/2024, passed in review petition number 106 of 2021 with WPC number 4729 of 2021 and WPC number 3386 of 2018 as the linked cases. Stop on perusal of this court's order. It is seen that a specific direction has been passed by this court to the Director of Secondary Education for implementing the order within a period of 3 months from the date of receipt of certified copy of the order. Stop. However, as the same has not been complied with, this contempt petition was filed on 1/2/2025. Stop. Pursuant to the issuance of notice Mr. U. Sharma, learned counsel, has appeared for which respondent, all the respondent number 2, respondent number 2. Now today, he has submitted a communication dated from the Director, Secondary Education to the Secretary, no, to the Secretary to the Government of Assam, Department of School Education. Stating that for the reasons assigned in the letter, the direction of this court cannot be complied with. To stop. It is seen that the order of this court was passed as far back as on 27/6/2024. And therefore, it is not understood as to why the director has only written to the state government on 24/7/2025 about the difficulty to comply with the court's direction. Stop. Under the said circumstance. No, cancel that. It is also seen that no show cause reply has been filed by the respondent number 2. And also the other respondents till date. Stop. Under this circumstance, the matter shall be posted again. Give a date after 2 weeks. On 21/8/2025. And by which time the respondent should file their show cause reply as to why the court's direction has not been complied with. Failing which, consequential orders will be passed for the personal appearance of the respondents concerned. Okay.
Right.
That part has already been determined in the earlier round of litigation. And the letter was submitted to the government, and government has passed the order saying that the school is eligible for provincialization, having the land. Now they are taking the same thing in the again in this important.
Show me the order which is to be complied with.
That is page 9. There are 7 in the relevant section.
There are 7.
There are 7, yes, 12. taking note of the submission of the learned that of the court side and on the issuance being given by Mr. Mojumdar, the learned is only counted for the external authority, also considering the given fact and circumstances on the record. This court is inclined to dispose of the petition by direct external authority to provincialize the service of the petitioner within a period of 45 days from today. If all the relevant documents required for provincialization service of the petitioner is found to be in order. I'm not clear. So for land is concerned, Lordship, I am placing that one document, Lordship, that when speaking order passed by the judge. In pursuance of the order passed in the other round of it. What they have said in that Lordship. Lordship, can be.
But Mr. Khan, there's some process going on, verification of the deed.
So the verification, but that has already been done. Lordship, I think the last paragraph of this case.
What is this?
This is the speaking order passed in terms of the earlier order of this honorable. In the earlier round of petition.
Which part?
Lordship, the last part of this case. And the next. It was the- of the conduct of-
You're showing me about the land possession.
Yes,
Then what is this gift deed?
it was in fact, it was.
Your land possession is on the basis of the gift deed.
TP. But it was the lab, declared by the structuralist. And the lab, what is that lab could not be registered. That's why was that part has already been lost.
Yes.
Three of these, become seventeen.
Huh?
Three, as per this, section, they have exclusive title and position over the land. This. Three, the concern, venture education institution marks that land in the name of the institution with clear exclusive title and position over the land before 1/1/2006. They have not the land in their name.
They don't have the land in their name.
Therefore, as per the mandate of the provision of this act, the department is not able to
But why don't you file that by an affidavit? If you have any problem?
After the hearing, also the computer pass get order. In the earlier round of. After the order of the earlier round. But how the three lordship.
Is there order minus make various minus?
The competition. After consider this document lordship, this honorable court has passed this order. That was the requisition.
He's right. Heard Mr. M. Khan, learned counsel for the petitioner. And Mr. P.K. Bora, learned counsel for respondent number 3. And Ms. S. Cynthia, learned counsel for respondent number 1. Mr. P.K. Bora, learned counsel submits that the verification of the gift deed concerned is awaited. And therefore, he prays for some time to come back with the up-to-date status. So in support of his submission, the learned counsel has produced the communication dated 37/2025 of the Deputy Secretary to the Government of Assam, Department of School Education, to the Senior Standing Counsel of the Education Department of this school. Next para, Mr. M. Khan, on the other hand, submits that there is no question of verification of the gift deed at this stage, in view of the fact that the speaking order has already been passed by the Secretary to the Government of Assam School Education Department on 31/3/2023. In terms of the court's order dated 37/2022 in WPC number 4859 of 2022. concluding that Purua Bahi Nagaya LP School is in possession of the land since the year 1994, donated by Purua Bahi Satra under Golaghat district. And therefore, the school is eligible for provincialization. Stop. Next, paramis S, learned counsel for respondent number 1. Which section? Page 109. Huh? 109. Which section? Submits that as per section 3, bracket, small Roman 3 of the Assam Education, open bracket, provincialization of services of teachers and reorganization of educational institutions, close bracket, Act, 2017. The venture educational institution must have land in the name of the institution with clear and exclusive title and possession over the land before 1/1/2006.
No lease or rent or owner agreement executed at any point of time will not be considered any next. It is also cannot be registered.
What is the result? Justice of Lordship authority of the Sotro was made party in the petition. He was appearing in the hearing of. He had submitted, he has no objection. Because land has already been dictated in 30 years, more than 30 years.
It can be registered.
Sotro cannot be registered. There are so many school, college, hospitals, but they are Sotro.
Next para, considering the above submissions. The respondent numbers 1 and 3, correct? Who is number 2? Who is appearing? Number 2? Then Narikar. Respondent number 1 and 3 shall file their so-called reply.
The last order, it reflects the figure. 2, 3, and 1 year. 4, 3 years.
Mr. A. Chali had appeared. If the respondents shall file their so-called, not 1 and 2, 1 and 3, okay. The respondent shall file their so-called reply within 2 weeks from today, stating the reasons for their inability to comply with the court's direction, failing which consequential orders will be passed. This is the case again after 2 weeks on a date to be fixed by the registry. They'll fix a date. Parties are represented by the respective counsels. May be referred. Should be referred. And they submit that the case may be referred for mediation. In view of above, registry to place the matter before the mediation center for necessary action at the earliest. I'm not fixing any date. Mediation center will fix accordingly. They'll give a timetable, routine and all that. And notice you'll have to go to the parties also. All right. Next.
I don't have objection, like, with regard to payment of salaries and all. This is self-mediation.
Anyone?
In department desk and.
No objection. Similar order. None appears for the petitioner when the matter is called. Matter stands adjourned for 2 weeks. None appears for the petitioner when the matter is called. Same was the case when the matter was listed on 16/2/2024. Case is dismissed for non-prosecution. Yes. Today it's listed for a referral to the mediation. Are you agreeable to that? You are agreeable? Yes. Okay. Refer. Okay. Okay. Same order this. Not possible. Okay, Mr. K.R. Padgiri, learned counsel for the petitioner, submits that the matter may not be referred to mediation center. Since, what is the issue?
Regarding old pension and new pension, the petitioner is dropped the
Since you since you cancel that, in view of the nature of the case, and in view of the issue involved in the case. Registry to list the matter. Yeah.
September, they're fixed on September,
In
the month of September.
September. To list the matter in the month of September or a date to be fixed by it.
Problem. No, single of let's continue passport to make a public. The single of let's.
You are there. Can it be referred? Mediation. It can be referred. What is the issue? Regarding retirement benefit. We'll pass it over then. Something. Respondents are agreeable, so you inform your senior.
I don't think anything benefit totally following the case because that is waiting to the regulation of the existing existing stay in the service minor. So and moreover, when I'm not releasing the VPF, that was already one of I have been paid till the date of my actual date of my employment, not the award state. So when I don't think anything will come out in the video. So they find the epidemic I have to counter.
Okay, it may not be referred.
Also, this matter will be back with WPC number 685 of 2025.
6/8.
685 of 2025.
What do you say, Mr. Mahanta?
Yes.
You are there in that case also, 6/85.
Yes.
Mr. P. Mahanta, learned counsel for the petitioner as well as Mr. K.R. Padgiri.
They are talking about.
Mr. A.R. Pahibildar, learned counsel, learned standing counsel higher education department, submits that the matter may not be referred to the mediation center, considering the issues involved. Mr. P. Mahanta also submits that he has to file rejoinder affidavit. In view of above, and as paid for, is the matter again after 2 weeks on a date to be fixed by the registry, along with WPC number 685 of 2025.
Awesome.
5 minutes, I'll come back.
Lord, I am in the production list.
Only that production list. Other matters are by some other councils. Okay. Total, there are 4, 5 cases.
Yes.
And all same issue.
Same issue in the sense, my lord, there I am told that matter relates to the diploma in here, the issue pertains to the certificate of that functional qualification BA. BA first certificate. Now,
Be it.
BA. Bachelor of Education. Here, Lordship may recollect. The other day, I submitted.
You are in the production case.
Yes.
Okay, then be the product. Yes.
So we submitted our application online. Ultimately, at the time of verification, Lordship may recollect here, it is the that come recruitment process. That come recruitment process, range. That come recruitment, research eligibility test, come recruit. That means who is eligible, who is found to be eligible is tapped. Research eligibility test. You will straightway go for recruitment. You will straightway go for recruitment, to my understanding, it was earlier different. That was a different component altogether. That was held separately. And the purpose of that is to create a pool of eligible candidates who can subsequently apply for the post of leads
You are an applicant for which post?
for graduate thesis.
Graduate teachers. Any particular subject?
No, no. Why?
Graduate teachers.
Yes.
And how many petitioners are here?
Why?
33.
Now, sorry,
33, I think.
33. 33.
Yes, and you're saying that you are TET passed.
Well, before I go further,
Uh,
if you allow me to make one correction here, one of the petitioners, 30, that name has to be treated 30. Nikita Das, because she was ticket for PGP. She comes in a different group. They are wrong. That 30, serial number 30, our name should be deleted for.
Petitioner number 30
33.
should be deleted. Okay.
So it should be here 32 petitions in total. After 33, one will be deleted.
Because the reason being that he or she is an applicant for PG teachers,
PG.
not graduate teachers. Okay,
That will be taken up separately.
all right.
Now here, so this eligibility test was not conducted separately, but the authority decided to hold that come recruitment process. That means the this eligibility test come recruitment.
Let us see the advertisement.
Yes, that page 35. Page 35.
Page 35.
Yes. So, you will find it was dated 26/12/2023. Applications are invited from the eligible Indian citizens as defined in so Constitution of India for filling up 7 to 49 vacant posts of graduate teachers, arts, graduate teacher science, graduate teacher council of the different provincialized secondary schools under the direction of the kilo players plus available. The district-wise, subject-wise, medium-wise, and category-wise post detail, as well as date and time of receipt of online applications for TT come recruitment test. And other details should be notified in the official website in due course of time. So that much here. ET, that is that term recruitment test. So here, the that exam has not been held separately prior to the initiation of the recruitment. Here, you say that would be considered a part of the recruitment process, and whoever qualify, they are will state to go for recruitment process for filling up the paper. And accordingly, we
What-
submitted
What is the eligibility criteria?
eligibility criteria here, Lord will see. Condition for recruitment. Just to chart. The post of graduate teacher arts, the candidate must be arts, commerce, graduate or postgraduate in arts, commerce, level. From recognized university with at least 50% marks, either graduation or post-graduation, or if equivalent, and Bachelor of Education from National Council for Research Education, recognized institution. So besides this degree, graduation degree or post-graduation degree, then this B.Ed degree,
B.Ed also is there.
yes, Bachelor of Education, B.Ed from National Council for Research Education, recognized it. Not from all, not only those who are first, the institution must be recognized by. For the post of graduate teacher, science, the candidate must be science graduate or post-graduate in science having from recognized university with at least 50% marks, either graduate or post-graduate or student. And Bachelor of Education being from National Council for Research Education. Three, as per Assam Secretary Education Procedural Services 2021, these institutions having territorial jurisdiction outside the state of Assam but having a study center in the state and some study center which was recognized by PhD under EGC, Research Education South Carolina, PhD, under EGC, PhD, certificate issued by us of campus certificate shall not be considered or valid. This is regarding the BS certificate, whoever they obtain some certificate in dispense mode that is minimum educational professional qualification for direct equipment for the graduate teachers in the KP. So this is the requirement. There is page 37. Criteria for selection of graduate teachers. Document company.
Yes.
Page 37. Research eligibility test cum recruitment test. 140 marks in the following question. The paper will be of 140 marks. That will be 50 marks. For the sum as its people. 50 marks, general English 30 marks, general study is current affairs 10 marks. And this is more told than final. 5 marks. 5 marks. Now, then, and we come to E, small E clause, the number of qualified candidates which is that of recruitment is shall be in the ratio 1:1. Okay, vacancies. And before D, lot of people say D,
1:1 means what?
1:1.
For one vacancy, for one vacancy, one candidate only.
What is two? Normally, 1:3 or 1:2. Now here they say 1:1. Or 1:4, that is if there is 50 assets, so 3 assets can be 40. Was there shall be one common question paper for all vacancies irrespective of if.
Yes. Okay.
Now. Clause H, next paragraph, next page, page 30. The merit list shall be prepared in the manner as proposed. If marks secured in the ET come with equivalent by the candidate of a particular state or instance that state shall be filtered out from the main list into a separate merit list of that state. Similar process will be adopted for all others. So, under the or the basis of merit, they will take out. On merit basis, those who apply for that art or the every wise, they will filter out and prepare the list separately of merit for each. Now we appear. We appeared, we were selected, and we were ultimately asked to appear before for verification of certificate.
Was there any last date for application? Online?
Last date of application was notified later on. Addendum was issued.
Addendum,
841.
what is the addendum? Anything relevant
Yes.
to your case?
In my case, Malar, only this was it.
Which one?
Clause 2 down below, how to apply. Roman 2. The online application will be accepted from 21st October 2024
15 November.
to 15th November 2024. This was again extended.
I see.
Which was again extended to 20th November. Next are 3, not 2.5. This notice was issued by which
20 November. This is the last date.
20th November. Page 44, Malay.
Yes, I got it.
Yeah. This was further extended to 20th November 2024. Right. So this was the last date we have given job. We accordingly applied. And ultimately, we were allowed to sit in the recruitment test. TET. TET was held on 19/1/2025. The test of recruitment process was held. And they declared the results on 19/6/2025. 19/6/2025. Page 79. That's a six lot. It was the notice issued by them. One of the things is download the market. Yes, page number, notice 40, page 79.
Yes.
This notice is hereby informed to all concerned regarding TT some recruitment examination. PCR, their quality short 2024, 44th of Desert Ticket, paper 1 held on 19/1/2025. That the candidates who are presently selected for document verification will be able to download their admit card. Well, maximum total marks, of weight A marks will be reflected. Such candidates will have to appear at the designated training on specified date and time, along with the required documents as mentioned in the admit card for document verification. So required documents must be produced on the day. All other candidates will be able to download their mark sheet, where total marks will be reflected, including the weight age marks, wherever applicable. The admit card or the mark sheet, as it may be, will be available for downloading from 11 AM on the page 635 at the official website of the Bank of Education. Candidates will have to log in by entering the application number password while filling up of the form when applying for the form. Now, Lordship, let's skip over. So they declared the marks, percentage of marks within the cutoff mark for unreserved, FC, SPP, FC, subject wise, for graduate teachers, science, art. So those marks are to 70.75, 63 in Bengali, 83 in Odo, 57.75 in English, 55 in 3.25 Manipuri, those actually 54.75, 61, 70.25. See how? 25. We have got more than this cutoff. Ultimately, we were asked to appear for the verification, and we have appeared. It's a mark statement in our case from page 81 and actually one of the candidates here before your lordship.
Mr. Mahanta, there's no issue on marks, isn't it?
Yeah, there's no.
Your issues regarding your B.Ed.
Only question is B.Ed.
B.Ed, that's what. Let us go on to that
That was
only.
placed on the date of verification. That was placed on the date of verification. And after verification, the annexation 9, page 131. One 31. Yeah, this is one of the candidates. The Ina Rahman. And down below it, I can follow. The ground has been given rejected and he produced the certificate issue date shown after the online application date 2011-2020. So we can make it to reject it. What's the product now?
Yes.
This is how we are. Now question is, therefore, on the date of verification of the documents, when we have produced the particular document, the B.Ed certificate, when that we have passed it, whether the authority could have rejected our claim. Now, law here is, okay, if it is specified in the, if it is not, that the document, there are two things. Document pertaining to the basic qualification and professional qualification. As I have seen it in the advertisement nowhere it is shown that all these documents can be uploaded or should be uploaded on or before the cut-off date, that is 20th of November. I think what that. Now, therefore, we possess all the documents pertaining to the basic qualification, graduation, and any other qualification, except that B.Ed certificate adequately we received just before the exam. We received it just before the recruitment test. But there is no provision for verification of the documents before the TCR result. Had there been a verification before TCR or kind of scrutiny done, carried out by the authority on that day, We could have produced it, they know. But they didn't. We said, in the examination, we have written it. And ultimately, when we came out with flying colors, we were asked to appear before, and we appeared. On that day was the designated day for submission of documents, verification of documents. And we produced on that. But the question is whether that could have at all been rejected. In Myra School submission, this is an illegal action, and legally our candidacies could not have been rejected on that ground. Well, it is not that we are not qualified. It is not that we do not produce, but it is that we have produced on that day. That day is the designated day when we are required to produce it. We are producing. One may say, why not you uploaded it? Right? If that question is raised, then yes, I can say, I could not upload it on that day because there is no provision also to upload. It is system. Other side is clarify it. But my definite instruction is that all these documents are to be produced at the time of verification. They will verify it on that day. I may just refer to one of the conditions. Yes, well, Lordship may only come to page 80. Or 38, sorry.
Page 38.
Page 38. There are a column called other criteria.
Yes.
Here Lordship will find. First, the candidate must have to give this voice of district all that. Second, if yes, two or more candidates obtain equal marks, then how to investigate qualification. All this is there. A candidate must not be less than 18 years to be more than 40 years. No person having more than 2 living children, that is, there, no offline application will be accepted in this regard. Then 6. This is important. The online applications and documents submitted by the candidates should be verified along with their original testimonies before appointment. The detailed schedule and a venue for screening verification of documents will be notified in the official website. Note here is a specific for specific. Now, this is your alert. Can you see? These will be verified along with your original testimonials before appointment. So, therefore, there was no provision for verification of the documents before appointment. Before TCRO.
No, verification is one thing, Mr. Manta. Says online applications on one part. The other part is documents submitted. What are those documents?
Document testimonial, the mark sheets are there.
You say that there's no provision for submission.
Yes, online.
Why should they give this?
They just put it. Document as such could not be uploaded. They will have to produce, they will verify it.
Documents are not to be uploaded.
Not to be uploaded. Only information are given in the online. That is why they said that all those will be verified before. The online 7. The online applications and documents submitted by the candidates will be verified using modern technology with the help of DigiLocker, Government of India, and by scanning barcode or QR code for ensuring genuineness of the uploaded document, as well as by back office verification with the completion board of the three. But the authority, if desires, may conduct physical document verification at any point of time with proper notice. This clause, as I understand, was kept as an alternative. Instead of direct going for direct original, I mean the hard copy verification, they may, online verification may to be done, provided there is provision for uploading those documents and through DigiLocker system, they could have verified it. Through back office verification system also, they kept it, but this was not given effect. This was never conducted. This was never given effect to and or carried out. Therefore, there was no scope. Now, kindly come to the next page. 39. Then, serial them. When the candidate appear for the verification of documents, they must produce the original certificate, testimonials and documents that were uploaded during the application stage. But there was no application. I mean, the uploading at the time of application stage. I may be corrected if there was so, but the my instruction is it was not. The system did not provide for. And therefore, those documents were verified in original on the day of verification. Now, Lordship may also kindly come to 12.1.2. The candidates having not cleared NC status against any qualification will not be eligible to apply. The candidate having not cleared status against any qualification will not be eligible to apply. That means if somebody has appeared in some exam that is not cleared, the authority will declare that this exam has not been cleared. No, not clear, not clear. That means having backlog or back paper not clear, then that will not be allowed.
You're referring to which part?
12, 1, 2.
12, okay.
Page 39. Lordship, lordship.
Yes,
The candidates having not cleared NC status. Now, who will declare this status? That the person has not cleared the particular exam, that will be institute. College, school where he studied, or the board, or the university under whom they appear, if they have not cleared certain exam, or there is backlog, then that certificate will indicate it. The 2, 3 papers, in one paper he could not pass. So not he is not eligible to apply. He is carrying with the certificate with the stamp of not clear. Therefore, that will be rejected. He will not be eligible to apply. At the very threshold, at the time of application itself, they will be stopped. They cannot enter the arena even of the recruitment board. Will be stopped at the threshold. Therefore, that being the situation, my report submission is our candidates would not have been rejected from. And it is the admitted position that we are on top of the merit list. The first batch to be called forward on the basis of what it marks. So 1:1. What do you think? They have followed the ratio of 1:3. Therefore, they go from the top of the merit. They won't follow any.
but if you are rejected,
If we are rejected,
then you'll be replaced.
that space will be filled up by the second one down below. This is the situation now going to happen. Annex of 10, they have declared that notice has been issued at page 164 that middle part notification. Further, second page, second
Yes.
paragraph only. Further, it is also informed that for document verification, the second list of some of the eligible candidates having to be along with the list of selected candidates will be displayed in the official website of the director of the only these candidates will be able to download their certificate and to appear at the legislative hearing on specified date and time along with the required document as mentioned in the request for document. Now, they have paid up, they have started the document verification for the second batch. And yeah, what you will see down below and that notice itself, the document verification will start from 30/7/2025. That note my lip. One. So, my anxiety is, they may go for filling up those forms. My publication of the final merit list or appointment list of candidates to the appointment. Then it will create complication. So if they decide ultimately, we may respond to it. My full submission is, even in the harshest case, the B.Ed course is such, the B.Ed course, a candidate who is pursuing a B.Ed course is allowed to participate in the test. And if the certificate is finally there, it is there, we can forget it at the final moment, verification, then we spoke. That is the law. My basic qualification has not been disputed. Only thing is that I am qualified, but I got the certificate after the last date of online certificate. Therefore, my full sufficient. Let them respond to my petition, what they want. And meanwhile, we will protect our interest. So that at least the equal number of posts shall not be filled up by them. Or they will not go for appointment unless they get the least possible. Or in active case, I will not be saying that the lawsuit will provisionally they can consider our case and keep it on record. That is also a way out. Provisionally, they can make the final selection, taking us onto record, but subject to your lordship's order. Required. That can be given if the subject is out of your law, this particular case.
Yes, Mr. Manta, I'll ask you. See, this B.Ed course is for how long? The duration? 1 year, 2 years?
2 years.
2 years. The petitioners, when did they undergo the B.Ed course?
We did undergo the B.Ed course 22-23 session from an university from West Bengal. Baba Sahib Ambedkar University. Baba Sahib Ambedkar University, because here,
All of them,
yes,
all the
all
petitioners.
of them. This is the difficult because there, the results were declared little later. Then the results which were declared here in our state.
Baba Sahib
Ambedkar
Ambedkar,
Education
Ambedkar University.
is 45 lakhs. Baba Sahib Ambedkar Education University. And publication of result were to be fine. Page 45. Down below, date of publication of result. Left-hand column, my lord. Page 45. Date of publication of result, 26/12/2024. We passed the final semester. Results were declared of the first and last semester on 26 12/20/24. And our result worksheet you can see in the right hand column. Semester summary is there in the part chart. So first semester, then credit, second semester, third semester, fourth semester. So total credit 80, total marks 2000, 84.45%. This was, you know, all these results are given, but all 26, 12, 24, 26, 12, 24, they are all from the same university. They are unfortunate, this happens, that they could not get admission in any college here in the state. They are from our state, but here, because there is lack of colleges, their colleges are not to that extent to accommodate all the willing candidates.
This is a distant mode
No,
or
no,
offline,
full time,
physical?
physical,
Okay.
physical. Going there, taking admission, staying there, they have to possibly go. Therefore, there, because of some disturbances in the state, the result was declared a little later. So it was supposed to be declared much before. But because of some law and order situation, getting those issues of getting doctor, I think it should stop the whole thing. Therefore, there were 8 people. Therefore, we could not get it. Before submission of the, the online. And there was no provision for submission of the document, so online mode also. But we had it before holding of the PCR. But before PCR also, no prediction was done, no scrutiny was made. And finally it was, as per their own declaration, verification, they will have to produce and report. First July 2025. Long after it was a matter of time.
1st July. That is the date on which you were produced. First verification.
Factor 9, the verification.
Page number, election 9.
131. 131.
Where did you get the date?
Down below 131, processing fine is.
Date and time.
Inspector of schools, PPC Bongaigaon, verified document 1/7/2025. The document of verification rejected on that very day when you produce it. They verified it on that day.
Okay. Another question, Mr. Manta. When you filled up the online application, what did you detail?
We have said that we have passed.
You said you passed before the results. In anticipation. And what did you upload?
No,
You didn't upload anything.
had there been that condition that the document must be uploaded along with, then probably we would have been out at that time. It is not there.
But doesn't it mention here, application and documents, it says.
But it was not done. That is why I said, but my instruction is not. that
And
you
it should be scanned in clear PDF format, all that. Specification is there.
was not there. They made a provision for online verification itself, but that was in fact not practically carried out. It was not practically done. That's why I placed that condition also. It was there, but probably some technical issues were there. It was not done. It was not done. And in fact, the scrutiny ought to have been carried out at any rate. Before you allow a candidate to sit in the examination. That is the right one. Yes, let us also consider the other side. That those who have applied, they have applied genuinely, they do not, because there is a condition they have put, that if anything is found misleading or anything is found that the ingenuine documents have been produced or should have been made, revealed, then in that case, otherwise, there is a condition here also, I found somewhere, I read it, that it will be scrutinized. Application will be cancelled. There was something actually. Because, but you know,
So Manta, that's basically your case, isn't it? There's nothing more.
nothing more, nothing more.
Now, okay, if you're done with your submission,
Well,
I want to put a question because there are some other matters also. Like yours is regarding B.Ed. There's another case with Assamese language.
Yeah.
That will apply on the same ratio.
Well, in my resolution, my case stands at a different,
Okay, different.
not with the diploma, because I do not know.
Hmm.
Not know those diplomas are to be issued by whom under what provision. Whether those are backed by any statutory deal or nothing that I do not know. Where from there to obtain, who will issue it,
Okay,
I do
okay.
not know. But my contention is that in case of PF certificate, the PF is to be carried out under the NCT guideline. NCT is cognition of the parent. And there is a provision that in the NCT guidelines also, that if one who is pursuing for such test, for such examination, a candidate who is pursuing a course, B.Ed course, is eligible to apply for the course without producing the final mark. Supreme Court has interpreted that even without appearing in the final exam, final semester, if he is pursuing the course, at any time he can appear, but only he is required to produce the first certificate when he goes for recruitment, that time he must.
Yes, you have an authority on that.
Yes.
Tell us, what is that?
This 2021 14
Page-
SCC 486.
2021.
Yes.
21 SCC, volume, which volume?
14 volume 14,
SCC,
486,
paragraph,
7.1. It starts from 7.1, Lord Simply kindly come to 7.3 straight away. How the Supreme Court will say here. This is the right and the same question, whether a person who is pursuing can appear in such test or not. Here it was the question of research training course. Part of the BA. Got it minus 7.3.
yes. Looking to the clear wordings, this one.
Looking to the clear wordings in clause 5.2 of the NCT guidelines and the phrase used in pursuing, the High Court is not justified in adding the additional riders, such as that to become eligible for appearing in the TET examination, a candidate must have appeared in the TTC examination and the result have not been declared by the last date specified for filling up the online form of TET examination. As per the dictionary meaning, the word pursuing means undergoing and or proceeding further. Therefore, a candidate who has been admitted in any of the TTC and undergoing the research training course can be said to be pursuing such research training course and shall be eligible to appear in the TTC examination. Irrespective of the fact that whether by the last date specified for filling up the online form for TET examination, he has in fact appeared in the examination of the research training course concerned, and the result is awaited. This is irrespective. Pursuing quote unquote, the requisite research training course is sufficient to make such a candidate eligible to appear in that examination. Therefore, on a fair reading of clause 5(2) of the NCT guidelines, a person who has been admitted in TTC, here Malawati 3 years, and is pursuing, she can appear in the TET examination. In the present case, admittedly, on the cut-off date, all the candidates who are pursuing the research training course concerned. Thereafter, all of them have cleared TET examination as well as have cleared the research training course concerned. At the time when they were appointed as assistant teachers, all of them fulfill the eligibility criteria for appointment as assistant teachers. All of them have passed TET examination and have also passed the TTC as per the requisite eligibility criteria. Thus, in our view, ousting certain incumbents by the High Court cannot be sustained since they were pursuing TTC and they were clearly eligible to appear in that examination and have passed it while pursuing the requisite professional qualification for being eligible to be appointed as assistant teachers. This ratio in final court solution is fairly applicable in my case because the TAT CAM recruitment and this that CAM recruitment process is nothing but the first part is the TAT. He must qualify there on marks. Then he goes for the recruitment part. Otherwise, he is not. Therefore, when on that examination, I have written that examination, I have taken that examination, that part, they have combined it, nonetheless, this is to be constituted to be a TAT CAM recruitment. Thereafter it comes. Only difference is that mark is taken into consideration for recruitment. Straightway, those who are in the high up 50 marks to be that, they would straightway go for. They need not have to fill up a form separately for recruitment process. That is the only difference, as I understand. Earlier, that was conducted, results were declared. Thereafter, the recruitment process was issued. Recruitment notice, once issued later, then they will have to fill up the forms and apply and so. Now it is possible in one go, in one form itself, you take first test, you go through the test, if you are qualified, you will go for the step. To cut short the process, as I made. The workload will be reduced, process will be quicker, that may be the reason. Therefore, in my school submission, yes, qualification under TET, when I can write, even if I didn't have the certificate in my hand on that day, but my case, my Lord, will see, when we wrote here, this year, we had the certificate. In our case, we have already got the certificate, but we could not get the chance to produce it. In this case, if you got that case, they didn't get the certificate on that. They produced it only at the time of verification. But in our case, we got it before the error come between. But we could not upload it. And we also could not have the opportunity to produce it. Okay. So those of that being the position, I have a strong priority. Subject to what they say, ultimately, what people have to. Therefore, my rights at the moment to be protected and it will not prejudice anyone. If you look into it from the other angle, whether this action will prejudice anyone? Can anybody say that, well, if you are permitted, we didn't do it that time? That is why I say, well, my case is slightly different from the others because the other documents, other diploma, other degrees I do not know of. But so far the BEd or teachers training course is professional qualification for the they extend the so they like the interpretation and if you pay that they are concerned while pursuing they can. Therefore, my rights were protected to level objective by the whole.
Okay. Before we hear the learned AG, the other cases, should we hear them first? Similar line, so that you can give one collective reply.
Yes,
Mr. Saikin.
yes.
I think,
My learned senior friend is trying to distinguish between the courses or eligibility criteria between his case and the other cases. So as such, Lordship may be pleased to hear something about the court that I'm considered. It will come online. And Lordship will give me tomorrow morning for my reply. And some difficulty in the second half. And so far as the other cases, we have already filed affidavit. In this case, we do not need to file any affidavit. So Lordship may take up the matter for final disposal during this proceeding. Because the other cases, the affidavits were duly filed and it is fixed for hearing. And this, my learned senior friend's case has come out of one time. So normally I would have asked requested for taking some time for submitting an affidavit, but that is not required because from his own material, I'll make out my case.
So my facts are not.
The only thing that my, no. Only thing that my reply may be heard.
today not possible.
Second or third, I'm not here. So the other side will also take some time. Otherwise, I was prepared to argue the case. Yeah.
Time constraint is there. Anyway, okay. We'll see.
My colleague will be here.
We'll resume at 2. I'll hear.
Lords.
Mr. Thakur.
Lords,
Yes, we will not file it. Yes, that may be recorded. We will not change our stand.
Because in that case, I will not. have
Everything
to-
is recorded in the camera.
I will not have to.
Court may not record it, but the camera records it. Court may not record it, but the camera still records it, so can't help it.
My statement is very responsible.
Yes, yes, definitely.
Not
That-
for fun that I have. made.
Advocate General makes a statement, court takes a serious view of that. The
I
statement.
also,
Uh,
because the whole record, there will be nothing. I will go by their argument only.
I will go by their argument. How many times they have.
No, I have the documents. I have the documents. I have
Their
the-
argument, how many times they have shifted. I'll make my argument. All right.
Regarding,
Safely out.
sorry, regarding my lot, I'm sorry.
I think. It's. Not the. This petition will not. For a good time.
what kind of petition?
Sir, I have clear activity create college, it comes some time for it. Now, a lot the extent with the council of the NCP. To the public notice, whereby students all the subject, if perform the private for the 21, 22, and 22. But according to the law, there is a now. Please going on between the government for the some of the information were not perfectly by this curriculum. So we could not submit it in time. Therefore, without our recognition has been, withdrawn. Now, the students will suffer below. And secondly, the last day, when the Mahatma University will announce the result and follow thereafter not, the students should be allocated to the respective college. That is the adjustment. That similar matter happened in different parts of the country. To stay over and to one or two orders, and all the high courts have started stay order. Only for non-submission of the performing of graduation. Tomorrow.
Yes. Stoppage? shortage of time for tomorrow, actually. There's a shortage of time for tomorrow. Can we have it on Monday?
Life of the students, sorry. Maybe second half. Understand? This matter of it over. Yeah. Take it back. What for the students take, because I am not a subject of either.
Okay.
Let's, I mean, matter 13.
Which, oh, that matter,
I don't know what 13.
item 13, huh? Maybe refer for me, there's a format kind of order which I've passed. It's the same order. Item 13. They will issue it from them. All right. Yes, Mr. Gotago.
May I please, Your Lordship? I am in item number 1, 2, and 3, Your Lordship.
Okay, which item will be arguing?
Item 1, Your Lordship. So far as my case is concerned, Your Lordship, it is slightly in different footing than what my learned senior counsel, Your Lordship, Mohanto's case is concerned, Your Lordship. Slightly in a different footing. His case is relating to professional qualification of B.Ed degree, Your Lordship, and my case is relating to additional qualification of Assamese diploma, Bengali diploma, Your Lordship, as advertised by the respondent authority. If Your Lordship takes up my petition, page 60, that is the advertisement, Your Lordship. Page 60, this is the advertisement. Your Lordship has already gone through the minimum educational and professional qualifications for direct recruitment in the post of graduate teacher, arts and science. We are concerned with this.
Yes.
We possess these qualifications, both professional and educational qualification, Your Lordship, as on the date of submission of the application form, that 20/11/2024. And then Your Lordship may kindly come to page 61.
What is 2011-24?
That is the last date of submission of the application form, Your Lordship. Your Lordship has already noted this, Your Lordship, in earlier petition. Now, Your Lordship may kindly come to page 61.
Yes, 61.
Bottom, Your Lordship. In addition to the academic and professional qualification as per sub-rule 10(5), sub-rule 1 to 5 of the Assam Secondary Education Provisional School Service Rule 2000, the candidate must satisfy the following criteria. In case of Assamese medium school, the candidate must have passed HSLC or equivalent examination with Assamese language as one of the subjects, or have diploma in Assamese language issued by the Assam Sahitya Sabha, or read up to HSLC level in Assamese medium school. Similar provision for, Your Lordship, Bengali medium schools, Your Lordship. In the Roman 2, Your Lordship.
Yes.
On the date of submission of the application form, Your Lordship, the certificate in respect of these courses were not with us, Your Lordship, as we are pursuing this course, Your Lordship. This diploma, Your Lordship, this is conducted by the Assam. Now, Your Lordship may kindly come to page 65. Your Lordship will find H, Your Lordship, the following self-attested colored copies of certificates and documents to be submitted online. Your lordship will find mark sheet of HSLC, HSLC, BA, BSc, BCom, pass certificate of HSLC, HSSLC, and BA, BSc, BCom, pass certificate, admit card in HSLC in support of age, certificate and mark sheet of B.Ed, certificate in support of scheduled caste, scheduled tribe, OBC, MOBC. Candidate with disabilities will have to enclose certificate of disabilities issued by government authority, certificate of NCC, B and C category only, certificate of recognized sports at national level representing Assam, certificate of achievement in fine arts and cultural activities representing state officially at national level, certificate of ex-serviceman issued by the Director Sainik Welfare Board. These are the documents, Your Lordship, one need to upload along with the application form, Your Lordship. Your Lordship will find there is no mention about the Assamese diploma certificate in this set of documents, Your Lordship. It is completely silent whether it is need to be uploaded or not. In fact, there is no requirement of upload the same. Now, if Your Lordship come back to page 64, Your Lordship, at the top, page 64, Your Lordship, at the top, Your Lordship will find clause 10, when the candidates appear for the verification of documents, they must produce original certificates, testimonials, and documents that were uploaded during the application stage. Your Lordship will kindly note that only those documents, as mentioned in the earlier next page, Your Lordship, page 65, which were uploaded along with the application form, that will have to be produced on the date of verification, Your Lordship. That means, Your Lordship, there is no requirement even to produce the Assamese diploma certificate even at the time of, Your Lordship, document verification also. Apparently, Your Lordship, going by the language of the advertisement, Your Lordship. Now, Your Lordship will kindly see the application form, Your Lordship, which is at page 75. This is the form we have uploaded, Your Lordship. Your Lordship will find the application form. Last part, Your Lordship, qualification details. All degrees must be acquired from recognized university board.
Yes.
Your Lordship will find, even here, Your Lordship, HSLC equivalent, HSLC or equivalent exam, graduate degree, postgraduate degree, professional qualification, teacher education, that is B.Ed, Hindi, Sanskrit. Do you having Hindi as one of the subject? No. Do you having Sanskrit as one of the subject? With 50% marks in graduation, graduate teacher, that's all. There is no requirement even in the application form upload or even to mention about anything about the qualification of Assamese diploma, Your Lordship. Your Lordship will kindly note that, Your Lordship. It was there. We have mentioned about it, Your Lordship. Your Lordship will get in the form itself. In the if we come down serial, Your Lordship, there is one column where language as one of the subjects, if any other than MIL. Your Lordship will get it, Your Lordship, at serial number 1, 2, 3, 4, 5, 6. Lordship. There, Your Lordship, we need to only mention whether, and that it has not specifically mentioned, Your Lordship, whether it is diploma in, we ourselves has mentioned that there is diploma in Assamese, Your Lordship. Now, Your Lordship, we participated after uploading this application form, Your Lordship. They have allowed us to participate in the examination, and in the written examination were qualified. And after qualification, they have called us for document verification. And at the stage of document verification, on the ground that we did not possess that diploma certificate, Your Lordship, as on the date of last date of application, they have rejected us. Prior to that, Your Lordship, will kindly note, Your Lordship, they have issued a SOP, Your Lordship, and that SOP, Your Lordship, will get it at page 92. The manner in which, Your Lordship, standard operating procedure for screening and verification, Your Lordship. Now, Your Lordship will see, Your Lordship, this is issued by the Director of Secondary Education Assam to the Inspector of Schools of different districts, Your Lordship. Subject standard operating procedure for screening, verification of documents, testimonials of the provisionally selected candidates for the post of postgraduate teacher and graduate teacher of different government and provincialized secondary schools of Assam. Now, Your Lordship will find that in the page 93, Your Lordship, documents to be verified by the Inspector of Schools. Page 95, Your Lordship, documents to be verified by the Inspector of Schools. Your Lordship got it?
95.
95. At the top, Your Lordship, documents to be verified by the Inspector of Schools. 93, Your Lordship, sorry, Your Lordship, page 93.
Yes.
Lordship. Now, Your Lordship will find that 1, 2, 3, 4, 5, 6, 7, 8. Your Lordship will kindly come to 8. Graduate, post-graduation mark sheet and certificate issued by UGC recognized college and university respectively. In case of degree obtained in studying mode, verification should be conducted as per the prescribed provision in Assam Secondary Education Provincialized School Amendment Rules 2021. The date of issue of mark sheet, etc. must be on or before the last date of online application received. This is in relation to Your Lordship, graduation and post-graduation. Then Your Lordship will kindly come to serial number 12. This is in respect of BA, Your Lordship. Mark sheet certificate issued by the university and institution having NCT recognition as mentioned in the advertisement. The date of issue of mark sheet, etc. must be on or before the last date of online application received. Then Your Lordship will kindly see the next. In the case of graduate teacher Sanskrit, again, the specific mention that the date of issue of mark sheet, etc. must be on or before the last date of online application received. So far, Your Lordship, so good, and these qualifications so far as mentioned. Then Your Lordship may kindly come to serial number 28 at page 95. Certificate awarded by Assam Sahitya Sabha, Barak Upatyaka, Bongo Sahitya or Sanskriti Sanmilan, if applicable, there is no mention that this certificate is required to be issued, Your Lordship, prior to date of submission of the application form, Your Lordship. While so far as the educational professional qualification is concerned, the SOP is very clear. The date of issue of certificate must be on or before the last date of submission of application form, and whereas so far as the certificate awarded by the Assam Sahitya Sabha, Barak Upatyaka, Bongo Sahitya Sabha, Sanskriti Sammelan, if applicable, there is no mention about the date of issuance of certificate, Your Lordship. Now, Your Lordship, this assumes significance, Your Lordship, in view of the fact which we have specifically alleged in our petition, read petition, Your Lordship, that this qualification, Your Lordship, is not an essential educational and professional qualification. It has nothing to do with the object sought to be achieved through the imposition of this particular criteria, Your Lordship. Your Lordship will know that why do you need to have this, to have a satisfaction that these graduate teachers who will be appointed can have conversation with the students in their mother tongue, Your Lordship. That is the only reason for which this additional qualification has brought in. It has otherwise nothing to do with the quality of teaching, Your Lordship. And therefore, Your Lordship, the SOP as well as the application form, everything from reading of both these two documents, it can be clearly seen, it can be clearly inferred that there is no requirement to have the possessing that particular qualification on the date of submission of the application form, Your Lordship. And that is why neither in the application form nor in the SOP made any mention about the date of that particular certificate, whereas so far as the other certificates are concerned, academic and professional, the SOP is very specific and the application form is very specific. Now, Your Lordship will find, Your Lordship, that we have made a specific averments in para 12 of our writ petition. Your Lordship will kindly come to page 166, last page of the writ petition, Your Lordship. What is the past practice, Your Lordship? What was the past practice, Your Lordship? Page 166. This was the consequent upon, Your Lordship, a recruitment process undertaken in the year 2021, Your Lordship. Now, in this 2022-1 recruitment process, Your Lordship, we have made a specific averments in para 12 that the authorities has allowed this certificate to be produced even after appointment letters were issued to the selected candidates, Your Lordship. Your Lordship, these are the 4 candidates, Your Lordship, who could not produce even after their appointment these particular certificate, and therefore their appointment has been cancelled. Now, Your Lordship will kindly see the name Krishna Bondo, subject botany, name of the district against which appointed Dhubri, and then order number by which appointed. Your Lordship will see their appointment is dated 14/5/2022. Means on 14/5/2022 they were appointed, and however they could not submit their this certificate, diploma certificate, till 22nd 27 of May. On the ground their appointment has been cancelled. And so far as this averments is concerned, the respondent authority has filed their affidavit. Your Lordship has clearly directed the standing council to bring instruction on this, and they have given a very evasive reply on that. We have bring this specific documents, Your Lordship. They have not denied this document, existence of these documents. They only in their paragraph say that they have not appointed anyone, Your Lordship, and even they have appointed, that will not give us any strength to our case, Your Lordship. That's what they have stated in their affidavit, Your Lordship. My humble submission here, Your Lordship, is this, Your Lordship. From the past practice that has been done by the respondent authority and the reading of the application form as well as the SOP, it clearly implies, it can be clearly inferred that there is no requirement at the time of submitting attaining the qualification of diploma in Assamese or Bengali on the last date of submission of the application form. We have that diploma when verification is being carried out, Your Lordship. We have produced that, and at a subsequent stage, this is an afterthought, Your Lordship. They have decided to reject our candidature on that particular ground, Your Lordship. Therefore, in my humble submission, Your Lordship, this rejection is bad, Your Lordship. Either they don't have the knowledge that what will be their action towards those persons, Your Lordship, who have attained the certificate after the cut-off date of submission of the application form, or they have subsequently, as an afterthought, have taken up this decision to reject our candidature, Your Lordship. Therefore, in my humble submission, Your Lordship, this rejection is bad in law, Your Lordship. And their affidavit is neither here nor there. Your Lordship may kindly take up their affidavit, Your Lordship, for a moment. They have filed. Para 10, Your Lordship, of their affidavit. It says, Your Lordship, para 10, that the advertisement also contained the other criteria section, which provides that the candidates having not clear status against any qualification will not be eligible to apply. Not clear means all qualification, including the Assamese, Bengali diploma course, etc. Now, Your Lordship will kindly note that to have that not clear status, one will have to have the option of uploading the mark sheet, uploading the certificate. When there is no option for that, then where is the question of having not clear status against the candidate, Your Lordship? Not clear status will be applicable in respect of those candidates who have not clear professional or educational qualification, Your Lordship, because those are the qualifications for which mark sheet will have to be uploaded, Your Lordship. When there is no provision for uploading, there is no mention in the application form about this particular qualification of the diploma in Assamese or Bengali, then where is the question of not clear status? Now then you should have come up with it clearly stating in the SOP or in the mark sheet and the application form that these documents will also have to be submitted along with this particular application form. When you don't come up with this plea and your past practice has created a legitimate expectation in our minds that our application will be accepted, then you cannot turn away in the midst of the game and say that it will not be accepted. Therefore, in my humble submission, Your Lordship, this action of the respondent authority needs interference by this honorable court, Your Lordship. Even Your Lordship will kindly see in the para 13 of the affidavit, Your Lordship, of their affidavit, para 13. They have relied on a judgment, Your Lordship, of the apex court, Ashok Kumar sir versus Chandrasekhar, reported in 1997 for C18. In fact, relying on that particular judgment, Your Lordship, I am submitting that these qualified petitioners, Your Lordship, who was otherwise more meritorious than the others, should be considered for Your Lordship future appointment in the selection process undertaken by the authorities. Your Lordship will kindly go through that particular judgment, Your Lordship. This was not 1997 4 SCC 18, Your Lordship. Chandrasekhar is 1993 2 SCC 611. Your Lordship may kindly go through para 15 of the judgment, Your Lordship. Para 3 is the issue, Your Lordship. The question which arises in the present appeal, para 3, Your Lordship, will kindly.
Yes, read.
The question which arises in the present appeal, whether or not candidates were fully qualified to be appointed as junior engineer on the dates of interview, but whose results has not been declared on the dates of submission of their applications, were entitled to be considered for appointment to the post of junior engineer. If the answer is in the affirmative, the appellants who had become qualified on the basis of interview and had admittedly acquired higher marks in the interview were rightly appointed as junior engineer on the basis of their merits and were rightly promoted to the post of assistant engineer by reason of seniority in preference to the respondents who were also appointed as junior engineer and subsequently promoted to be placed junior to the appellant. Now Your Lordship has seen, Your Lordship, that very question is on the date of interview they have the qualification, but on the last date of application they did not have. Then Your Lordship may kindly come to para 15.
Yes.
The fact is that the appellants did pass the examination and were fully qualified for being selected prior to the date of interview. By allowing the appellants to sit for the interview and by their selection on the basis of their comparative merits, the recruiting authority was able to get the best talents available. It was certainly in the public interest that the interview was made as broad-based as possible on the basis of qualification. The reasoning of the learned was thus based on sound principle with reference to the comparatively superior merits. It was in the public interest that better candidates who were fully qualified on the day of selection were not rejected, notwithstanding that the results of the examination which they have appeared had been delayed for no fault of theirs, Your Lordship. Now, therefore, Your Lordship, even in case of this, Your Lordship, the Honorable Apex Court has clearly held that if they are better qualified, if more meritorious candidates can be brought into the service, these kind of technicalities should be avoided. And that too, when this qualification of having Assamese diploma is only to ensure that the selected candidates clearly, properly able to converse with the students in their mother tongue, Your Lordship. Otherwise also we have that capability, Your Lordship. But they need a certificate for that, and that certificate we have. But not on the date of submission of the application form, but on the date of submission of the on the date of the verification of the documents. They could have, your lordship, they cannot interpret this SOP to reject our claim, your lordship. And your lordship will kindly see, so far as the past practice is concerned, on that point also, your lordship, I am relying on a judgment, your lordship. And this is only for the purpose of your lordship interim prayer, your lordship, that is official liquidator, your lordship, on legitimate expectation, your lordship. Page 1, para 102, your lordship, of that judgment.
Page number 1.
Page 102, your lordship. So page number 1, your lordship. Para 102, your lordship.
Yes.
Lords. The concept of due process of law has played a major role in development of administrative law. It ensures fairness in public administration. The administrative authorities who are entrusted with the task of deciding lists between the parties or executing upon the rights of individuals are duty bound to comply with the rules of natural justice, which are multifaceted. The absence of bias in decision-making process and compliance with Odi alterem partem are two of these facets. The doctrine of legitimate expectation is a nascent addition to the rules of natural justice. It goes beyond statutory rights by serving as another device for rendering justice. At the root of the principle of legitimate expectation is the constitutional principle of rule of law, which requires regularity, predictability, and certainty in the government dealings with the public, your lordship. Your lordship will kindly note these lines, your lordship, that the root of the principle of legitimate expectation is the constitutional principle of rule of law, which requires regularity, predictability, and certainty in governments dealing with the public. Now, your lordship, it will have to be the certainty, regularity, and predictability, your lordship. They cannot be unpredictable. They cannot be uncertain, your lordship. On the one hand, they are on the last occasion, your lordship, last recruitment process, what they have allowed. Now, predictability, certainty, and regularity requires they follows that principle. And they, if they want to deviate it from that, then they will have to have certain instructions which are clear. There must be clear mandate of either of the executive instruction or the law, your lordship. In none of the cases, in the present case, that predictability is not there, your lordship. Your lordship will kindly come to next page, your lordship, para 103. Para 103. In Halsbury's Laws of England, the doctrine of legitimate expectation has been described in the following words. A person may have a legitimate expectation in being treated in a certain administrative authority, even though he has no legal right in private law to receive such treatment. The expectation may arise either from a representation or premise made by the authority, including an implied representation, or from consistent past practice, your lordship. Now, the past practice herein is, your lordship, what I have already pointed out to this honorable court, your lordship. And that being the position, your lordship, if the authority absolutely has the right to, your lordship, abandon the practice and go for, your lordship, the new terms, your lordship. But that will have to be clear. Neither the application form nor the, your lordship, the SOP clearly mandate that this particular certificate must be there with an applicant on or before last date of submission of application form. And rather than that, what we can infer from both these documents, your lordship, that there is no requirement even to submit these documents, your lordship. And when there is no requirement, there is no question of being not clear status, not having the not clear status. And all of a sudden, by interpreting the SOP in a different manner, you bring in certain interpretation by which you reject our claim, your lordship. In my humble submission, that is bad, your lordship. Therefore, in my humble prayer before this honorable court, your lordship may issue notice on this, your lordship, and in the meantime, your lordship, we may be allowed to, my cases may be considered, and that outcome may be subject to the ultimate outcome of this particular writ petition. This is my humble submission before this honorable court, your lordship.
What about the other cases? That also is regarding this language.
Regarding the diploma, I did not have, the third case, I did not have the diploma of the last date of, but I,
Diploma in what?
diploma in
Same thing like Mr. Botakur. So
but I, yeah, but I just get some.
you want to add some spice, some more spice. See, we have to adopt, I think we don't need, we not hear you in detail also. Basic. If you have something more to add,
Yes, regarding the, yes, okay. Test was conducted different and equipment was different. Only thing are all other previous okay. Test was conducted with different company. And after passing of test, equipment was for equipment. The procedure of equipment has been given in schedule 2 of the 2020 rules. Document is calculated 100 marks of year, 100 marks in HS final, 100 marks in year, 100 marks in CAT. Therefore,
what is that?
schedule 2 of the rule. Page 80 of this. And nowadays, X is Assam Secondary Education, Government Civil Service Rules 2020.
Regulation of posting and transfer.
So, Assam Secondary Education. Secondary Education, Government School Service Rules 2020.
Okay, it's here. Page 7. Yes, which part you are referring to? Schedule 2. Schedule 2.
Criteria for selection of the at this time.
Yes.
So basically,
Mm,
the screening
yes.
of certificate. The graduation certificate, the teacher certificate, the grade certificate, and the test. Therefore, though the field recruitment of test starts on 26/12/2023. The recruitment for the post of arts and science teacher starts when the screening starts. That is on 27/5/2024. Right,
27/5/2025.
when the SOP is given for screening.
Okay.
Therefore, what you would see in the main advertisement on 26/12/2024, they do not require this certificate to be uploaded because that was a TED exam. So
the recruitment is not a test. It's a screening procedure. Combining of the marks. So though the advertisement is shown as test-cum recruitment, then the recruitment starts on 27/5/2020. This is the procedure of recruitment. Normally, they could not have issued both the advertisement together, and if the lordship, I will place the rule. Strictly, they could not have done this. One is eligibility test, one is test for recruitment. In earlier rules, it is amended now. In earlier rule 10, there was a specific condition that passing of this test will not give any right for recruitment or selection. There was a specific proviso to it. Now, meaning thereby that 26/12/2024 advertisement was an advertisement for TET exam. What was we applied for was for TET exam.
What is the process for TET examination?
TET examination, we need, they give an advertisement. If we are otherwise qualified, then we can appear.
No,
So
no, TET, does it include any written test, anything like that?
TET is a written,
TET is a written test.
TET is a teacher's eligibility test.
Then what is the recruitment test then?
Recruitment has no test. Recruitment is a combination of certificates and calculation of by adding of marks. All the
So,
marks will be added and you will be recruited.
so this schedule 2 which you have shown me, what is this?
Yes, schedule 2, Lordship, I'll show you.
This is recruitment test.
Recruitment.
This is
procedure
recruitment.
of recruitment.
This schedule 2.
Schedule. Schedule 2 is a procedure of recruitment. So, Lordship, I'll show it again. 100 marks on percentage of marks of CA from examination, marks obtained so and so. 100 marks on percentage of marks in HS final, 100 marks on percentage of CA examination, and 100 marks of marks in TET examination. So they combine it together. Now 50 marks for so and so, 10 marks, so and so, 10 marks for participating in national sports, 10 marks for final. They combine all together, and whatever comes out in merit, they will, as part of post, they will be recruiting. My point is therefore, the cutoff shown by them on 2011-2024 is a cutoff for the examination.
Not for the qualification of additional subject or.
Yes. That is an eligibility test. This is a recruitment. Recruitment starts when the screening starts. Screening is done by the SOP. SOP is published on 27/5/2025.
So that is when the
Screening process starts for recruitment.
the certificates are required to be
Yes, look.
scrutinized. Prior to that, we had just wait for the test.
Yes, look. Now, in light of this argument, Lordship will test my argument from the advertisement now. Lordship will see at page 40, 36 of my petition. The examination starts. Now at page 40, my senior has already shown that these are the certificates. Equal. I will also come to the SOP. Now, this diploma certificate is not required.
Yeah, that is already said, right?
Yes. Now, logic is the SOP.
Page,
Is logic start from 58.
yes, which part?
Yes, sir. Now, I will just, how it is different from the other DA case, I show you it. Where,
Those are mentioned, specifically mentioned.
yes, we clearly mentioned that where the date of issue of mark sheet must be on or before the last date of online advertising. It is mentioned. In my case,
Language is not mentioned.
language is not mentioned. Language is mentioned in scale number 28.
But it doesn't say about the dates.
Yes, sir. Because it's not required. Secondly, Lordship, I come to the rules also. Firstly, since I'm in the SOP, I'll just point out at page 62. Grounds of rejection. Bullet number 3.
Yes.
The issue date of documents related to qualification, task, etc. in respect of candidates must be before or on or before the last date of filing online application, that is 2011-2020. Documents issued after 2011-2024, any document will be allowed 3011, shall not be taken into consideration under any circumstances, and the candidature of such candidate will summarily be rejected. Now, the issue date of documents related to qualification. Now, Lordship would see, is this a qualification? I'll place the rules. Rule 10. The same book or rules of 2003. But I'm trying to be as brief as possible.
Yes. Who then?
10, rule 10.4. Subrule 4. In addition to academic and professional qualification, as per subrule 1 above, the candidate must satisfy the following criteria. Therefore, the rest of his qualification, academic or professional. This one is a criteria.
How does it differ from criteria?
Lordship, criteria, I was searching for a judgment, hopefully I will get it tomorrow. But the criteria qualification is required for the exam, right, at the threshold. Criteria is required for assessing the merits after the exam. That is the difference in dictionary I could find, but I'll certainly see for a judgment. So, as per the rules of it is not qualification. It's a criteria. But if the possible meet the requirement for one, something I'll just read it up. In case of Assamese medium, the candidate must have passed HSLC or equivalent examination with Assamese language as one of the subjects, or having diploma in Assamese language issued by the Assam Sahitya Sabha or less up to HSLC level in Assamese medium. Why? What is the purpose and object of this? Purpose and object of this is that you have to have minimum exposure to Assamese. The qualification and professional is required to teach. But here, it's a criteria. The recruitment process has eligibility condition, condition of service, and conditions of recruitment. This is not an eligibility criteria. This is a condition of recruitment. Therefore, all the judgments which says the last date should be before filing of application. Will, that law is also not settled like this, Ashok Kumar Chatter's case. But their judgments, all judgments are regarding eligibility criteria. This criteria is not the eligibility criteria. This is also not a qualification. Even the advertisement says that documents related to qualification. As per, I have read the rules as it is. This is a condition of recruitment. There come and moreover, the entire objective, if such a interpretation is given, that you must fulfill this criteria also before the whole object will be frustrated. The object of the recruitment is to bring the best candidate first. This is a condition of recruitment. This is even not required by the advertisement. Therefore, I was thinking why they have made the difference in the rules also in the advertisement also. In before 2 or 3 years, what has happened? They conducted an examination in BKD. No, they are not even how the posts were filled up. Because nobody was qualified. So they took a chance that if there are more candidates, we will impose this as a last date of application. But if the advertisement also doesn't say like this, the rules also doesn't say like this. Therefore, the last date of online application relates only to eligibility criteria, not conditions of recruitment. It is just a criteria. In 1993, and regarding the last date of eligibility, all the cases that have been faced and that have been shown in the affidavit is given by the Honorable Apex Court, mostly of a two-member bench. But the judgment which was faced by my senior, the Bottas, was a judgment given by 3 members. It is well settled that if there is a conflict of opinion, the larger bench will, and a smaller bench of a same, the larger bench will pay division. That's it. Therefore, that is my humble submission.
So any other case on this subject? This is item number 4, isn't it?
The SOP screening test starts from 27/5/2025. I have my certificate on 11/2/2025 before the screening. Before the
11/2/2025.
The screening test starts from, recruitment test starts from but we had a query regarding what was the requirement for sitting that examination. There is a notification of 2011, but I'll read tomorrow.
This is a single petition, isn't it? So this takes care of all the matters, I think. AG will give his reply tomorrow.
But let us notify, let us participate, let us, our selection will be made something.
You've done your part, so tomorrow I'll hear the AG, then thereafter pass necessary order. See, even that, what do you call, production list, that file is with them. It belongs to somebody. Belongs to you. Can just get a printout of this now. Okay.
Deeply obliged, your lordship.
Please write down. The learned counsel for the petitioners have made their submissions. This matter again tomorrow. Give the date. 1/8/2025 for a response from Mr. D. Cycle and additional application. ASAP. Yes. You are there on the other side.
Yes, I'm for the university.
Which university?
Cotton.
Typing. Yeah. Oh. Oh. Yes, you were saying? It's 21. Yes, serial number 2. What is this document? What is this document? Who has prepared this? Okay. So instead of your name, respondent number 6 name was 10. And his service has been provincialized. No, on which subject? All subjects. All subjects. So why do you say that you should have been provincialized instead of him? How? From? 21. In page 21, where is the name of the respondent number 6? Oh. No. This is in respect of a particular school. So wait. So how many teachers' name has been referred here? 3 teachers. One Nehar is there. And Abdul Aziz. His name was not there in that. This annexure 6 is what? This is a dice code. That B. That B. Venture. Just a minute. What is the running page number? 32. Yes, paragraph 4. So some mistake has been committed by the food inspector. No, they came for inspection. On 12/5/2005, they came for inspection. Wherein name of the headmistress and the petitioner was captured. But later on, when the dice code came, name of respondent number 5 appeared instead. Oh, I'm sorry, it appeared. It appeared in the dice code. But then how did the provincialization happen? No, after the dice code, this is sent to the district scrutiny committee. No, it is the district. Page 24, isn't it? Why there is so many signatures here? So many of them. So the headmaster, headmistress has filed the affidavit. And who else has filed affidavit? Who is respondent number 6? Private respondent. Headmistress. What about the other official respondents? They have not filed. Why? You have no instructions over.
No, exactly, then we have missed this file yesterday, noted. Anyway, there's a provision for file and appeal and section 14 noted, page 120 of this book noted can be present. That yes, to the file and appeal for the record of the authority noted. There's a provision in the act.
Matters pending is 22.
Even provision, they have not followed the provision of it. Never be, if they may lost in a disposal direct, asking them to file an appeal under section 14 noted before the appropriate authority.
Where's the provision?
Page 123 lost in a calculation. Pending doesn't matter, lawsuit, the provision provided in act lawsuit, they should follow the act first, lawsuit. Pending of the case doesn't give an absolute right to.
No, I understand. Let me hear, Mr. Artist.
Lawsuit can pay this book lawsuit,
Page
page 123,
23.
123. Assam Education Functional of Service of Teachers and Reorganization of Education Institution Act 2017. The fifth is section 14, appellate authority. The state level scrutiny committee shall be the appellate authority against any recommendation of the state scrutiny committee. And the state government, the concerned administrative department shall be the appellate authority against the recommendation of state level scrutiny committee. Now he given this against the scrutiny committee. So he should file an appeal before the state level scrutiny committee, that is the director role.
Director.
Yes, sir. Director is the 7 of state level scrutiny committee.
Chairman.
Yes, yes.
Where is the constitution of that state level? It's here on the.
Yes.
On top of the page.
Yes, yes,
Section 13, subsection,
10.
subsection 10.
10.
That is there, no doubt, but, see, matter was list taken up in 2022, notice had gone.
That is all right,
At
but
the
there's a
stage-
provision in the act, that should be followed properly. But if similar kind of cases are before the ETC only, they have to file an appeal under section 14 and the chairman will consider properly.
What is your instruction of the?
That instruction is still located, this case we have missed it yesterday, I have get a second copy from this court of it. I will place it on next Monday or Tuesday or Thursday. Or next Wednesday. Or-
What is the situation of next?
No, I need to do your lock 14.
So, or 1890.
Yes, sir. Yes.
Okay. Heard Mr. Z. Ahmed, learned counsel for the petitioner. Mr. E. Ahmed, learned counsel for respondent number 5. Mr. S.M.G. Chisti, learned standing counsel,
Elementary.
elementary education for respondent numbers
Let me know 1, 2, 4.
1, 2, and 4. And Ms. D. V. Burma, learned additional senior government advocate for respondent number 3. So the brief facts of the case has already been recorded in this court's order dated 21/9/2022 and are not being repeated for brevity. To stop. The Department of Elementary Education has not filed their affidavit. Although the respondent number 5 and 6 has filed their affidavit.
But the private respondent has not yet. I think here's the private respondent, again from here the grievance.
He has not come, private.
I think he has not.
6.
EJ had this, he has nothing to do, but with the private respondent, that is the main person against whom he has.
Then you got 6. 6 not required. Private not required. But what about notice? Is it complete? I'm concerned about six. What has happened to six? Oh, six has filed. Then don't cancel. Five and six. Mr. SMT Chisti Lanet, council prays for 2 weeks time to obtain instruction in the matter. You about this matter again. In August. The other day. Okay. 26. Tuesday. Fine. As agreed to by the parties, list the matter on 26th of August 2025 for admission hearing. Deeply. Yes. Medical reimbursement. You want to send it for mediation? Shall we have it some other day? Maybe one of the 2 days. Time constraint is there. No, we have it on the second last week, perhaps. Subject to what you say, either 19th or 21st. 19 August, Tuesday. As agreed to by the parties, list this matter for admission hearing on 19th of August. Keep the plan. They have not filed. Page. Just a minute, okay? Just a minute. Just a minute.
Last petition, I think, directed to file affidavit. For that, followed by the time.
You are relying upon WPC 938. Similar case. You're no longer working, isn't it? Are you working? You've been terminated. You are working on what temporary basis? See, the idea behind appointment under 3F is not routing through the APSC. When the appointment is not to a permanent post, which is not to be last not more than 4 months, then 3F is imposed. Why do you want an appointment for 4 months? Correct. Where is the cabinet decision? Page? What are these? This part-time. Part-time lecturers in 257. Then. Hmm. Yes. But one thing which I fail to understand is, you see, 3F is 3F is an appointment which is not on a sanction post. 3F, appointment under 3F. Appointment under 3F is not on sanction post. Not on sanction post. But here it says that instead the cabinet approved engagement of these faculties on ad hoc basis against sanction post in accordance with the principles outlined in regulation 3F. See, just see 3F, what does it say?
Appointment under 3F, according to the principles outlined here.
Principles.
As like here.
3F says temporary post.
Yes.
But this minutes says sanction post.
This arrangement is something different, my lord.
So there's a contradiction. The moment you say sanction post, it cannot be 3 years.
This arrangement was made for a period of 4 months, my lord. The, the, uh, the, the contractual employees, they were, the cabinet has decided to engage them for a period of 4 months in accordance with the principles outlined in regulation 3. They are not appointed as peer appointee, but the principal. What is
Okay, then, okay, the principal. Now, but now why appoint some? Why don't appoint, you not appoint some?
One of the list finally have
There are
69, they are challenging that list, my lord, actually, but their name are not reflected in that list of 100.
257.
And as of now, my lord, as of now, nobody is working those posts, my lord. The regular appointment has been made, and in all the polytechnics, regular appointment has been made. Nobody is working from this list. Earlier, my lord, to ask my lord, approve your law. We have not been here by
The next 8.
the 18. That is not. They have to all the technical. My fear is that for the technical system, we may be able to. 4 months, 2 months, 5 months, whatever. And I must be all are all are. Okay. They were on the current 38, they were appointed. Now, out of 257, 19 people, all are central. This is the advertisement. And this is the result. The result.
other than 30K out of 257. I don't think my lord, playing second, that's why we are for your law.
See, do one thing, why don't you file this by way of an additional affidavit? Bring it on record. They'll be better. Which Thursday may not be possible. You are Mr. D. Barwa. Mr. D. Barwa, Lanet Council for the petitioners. Raise that. There are certain developments in the matter, and that he may be allowed to file an additional affidavit to bring them on report. Whereas allowed. Let the additional affidavit be filed within a period of 1 week. 1 week? This,
The last direction, court has directed to file affidavit filed from the government. That's number 1 and 2. That is the secretary of education. For,
you are paying for 1 and 2 also?
yes, ma'am. I have already filed affidavit from the director, madam.
Yes,
On the last occasion, Malad is directed to file affidavit.
by the state government.
Yes. So, Malad, I'm yet to get the inspection. So that 1 week will be Malad.
Okay, then 3 weeks then.
I don't think that given the court 40 days. 40 days by law. Using 40 days, man, I think doing nothing. He's not complying with chips or that. Now he's seeking another 2 weeks by law. One will be given by law. One will be given.
Malad has put some specific query, Malad, in that order.
But
I have.
For a fact, which affidavit he has filed, in each affidavit matter, the director has been authorized by the respondent number 1 and 2, man. In the first paragraph,
Anyway, since we have passed an order, so it is further seen that the respondent numbers 1 and 2 has not filed their affidavit in terms of the court's order dated 24/6/2025. So as such, Mr. S. Das, Learned Standing Council, Higher Education Department, will obtain instructions and file the affidavit of respondent numbers 1 and 2 by the next week. Let's begin.
He will also file affidavit, and because as per my instruction, there is no post panel. Only the post which I believe filled up file with promotion, that is only there. So in the meantime, he will file affidavit. I will also bring instruction with respect to that affidavit.
Okay. 27th of August. It's the date of 27th of August. You take back your document. You take back your document and file it by an additional affidavit. On which date and a endeavor should be made to dispose of the reputation. All right. You will know. You are there, madam. What is this state? Who's your senior? Yes, doctor. Who's for the other side? Dibrugarh University. Who's the council? No, he's not there. He's come over this side now. Be cautious.
Google is supposed to appear. It's true, or no?
33.
Google is supposed to appear by this code. Who? Google, what's the Google?
K Gogoi. Or Dibrugarh University.
For. Yes, sir. After the time is done, because earlier मतलब for digital and वैसे मतलब
Mr. Majumdar was there. Yes, he's come to the bench now. So some arrangement has to be made.
but Google was supposed to appear, but I have no instruction what.
How, in what capacity he'll appear? Is he also the standing counsel?
No, मतलब
Then on Vakalatnama he'll appear. Over.
but I have no instruction. But Mr. Google.
Take instructions. This is the second round, isn't it? Second round.
Thing that
In the criminal case. Correct. The same set of charge in the criminal case and in the disciplinary proceedings. Facts are same. You are acquitted in the criminal trial. I see. Your what capacity? Section officer. And the other officer? Controller. Okay, when do you want it? When So this is not the time for passing over the time being. See, hardly any time. Okay. Mr. R. Majumdar, learned, the engaged counsel has since been elevated to the bench. And court is informed that Mr. R. Gogoi, K. Gogoi, will be conducting the case.
Today, he said that he will appear. I don't know whether he will be appearing for.
Okay, just repeat sentence. And the court is informed that, the remaining cut, the respondent university will be making some alternative arrangement. In view of above, unless this matter, 2 weeks on the date to be fixed by the registry. The date, they'll give,
After long time.
they'll give a date. Otherwise, you have to make a and be able to. Yes, Mr.
Yes, it's a development of the.
You'll be appearing in this case.
I'm appearing.
How will you appear? Where by way of power? You're the standing counsel.
They now propose to appoint me as standing counsel, therefore, development is going on.
Okay.
Let after 2 weeks.
Or after 2 weeks on a date to be fixed by the registrar. Yes. Okay. Oh, just a minute. This is regarding SSA. Who's the counsel for SSA? Who? He's not come today. This was a part-heard matter. When it was released. Oh. Released on. It will take some, correct, but it'll take some time, perhaps. We have a date sometime. Twenty-seventh of August. Due to paucity of time, the matter cannot be taken up today. So since the matter is of the year 2018, and as paid for by the parties, that the matter will stick for hearing or 20. Did I say 27? So we have it on 28, we said. 27, when is it? 28, on Thursday. Hearing date. This is for hearing, isn't it? Yeah. 28 August. What is the issue here? Regularization. As what? 2nd of September. This good enough. Short date. 2020 matter. 2018. Same date. Okay, let it be 28. See. I see. Then we. How many are there? Hardly few days only, 2nd of September, only better. I have to. All right, that's quite a party, the matter for hearing on 2nd of September. 2022.
This matter also from length of hearing is required. Very-
Give a date, the master. Okay. Right. That's make for quite a part. It's the matter on 9th of September, not for hearing. Not. Okay. Sorry? Area. Who's for the other side? BTC. There was no one today for BTC. B. Chaudhary was here also. He's for BTC. B. Chaudhary, then who is that? It's Bora. Yes, Bora. RB Bora is also there.
Last.
Okay, please also give a date. That's great. You'll have to go to September only. This is the matter on so and so. 9th of September for hearing. What are these matters?
Already ordered at length.
What is the matter regarding? Retire benefits.
Retirement benefit, the petitioner is claiming, our stand is that their appointment itself is illegal.
Illegal.
They were,
Then why didn't you terminate them?
they were subjected to that.
You allow them to serve till the retirement.
And I afford this court, they afford me, they just like to come. I initiated it. After I working 30 years of work, I start, they send me, they put me to for training. I have the training, it will regular pay scale. Some petitioners have been 70 from far. And after retirement. And so that's also, yeah, after determined, and you cannot be questioned about the
Okay, give a date. 11.
11th September.
As paid for by the public, is the matter for hearing on 11th of September. These are all similar, 38 to 41. So,